ಸ್ಟ್ರೀಮ್ ಸ್ಟಾರ್ಟ್ ಸಕ್ಸಸ್ಫುಲಿ ಅಷ್ಟೇ ಆಯ್ತು. ಹಾಂ ಓಕೆ, ಈಗ ಲೈವ್ ಹೋಗ್ತಾ ಇದೆ. ಈಗ
ಮೀಟ್ ಮಾಡಲ್ಲ. ಹಲೋ ಮುದಸ್ಸೀರ್.
ಬೇಡ ಸಂಗತಿ ಅವ್ರದ್ದು ಒಂದು
ಹಲೋ ಹಲೋ ಇಲ್ಲ ಮುದಸ್ಸೀರ್. ಹಲೋ
ಹಾಂ
Mandamus. Please. Please.
On the election matter, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, my nominations has been rejected on the ground that deposit receipt are not produced. ನನ್ನ ಹತ್ರ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ, ರಿಸಿಪ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಸೊಸೈಟಿಗೆ ಯಾರು ಇದ್ದಾರಾ?
ಇದ್ದಾರೆ ಸರ್, ಅವಿಲ್ಲ ಸರ್ಚ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಸರ್ ಕಾಪಿ ಅವ್ರಿಗೆ, ಪ್ಲೀಸ್. 2:30.
Adjournments, page 14, 52 to 56.
Serial number 54, my lords. Petition becomes infructuous.
54, petitioner is before this court seeking for the following relief. And counsel for the petitioner submit that the relief sought for have been rendered infructuous.
Yes.
Accepting his submission, petition is dismissed as infructuous.
Please.
Serial number 55, my lord.
Huh?
1 week time will kindly be granted. Senior is not well.
ನೀವು ಯಾರಿಗೆ
For respondent number 1.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಾ ಎಲ್ಲರಿಗೂ?
I have phone ಮಾಡಿದ್ವಿ. I have called him. He's not receiving. I'll intimate him.
It is not informed. Inform ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
Intimate ಮಾಡಿ.
ಇಂಟಿಮೇಟ್ ಇಲ್ಲ.
Please.
Page 15, 57 to 64. Page 16, 65 to 72.
My lord, serial number 69, my lord. I seek weak accommodation for the respondent, my lord. I informed to the petitioners.
69 at the request of counsel for respondent number 3.
Yes,
Relist on 23rd January.
much of it.
Page 17, 73 to 76. Page 18, 77 to 79. Orders,
ನಾಳೆಯಿಂದ ಹಳೆ CPCs, oldest CPCs, WP CPCs will be listed 50, 50, 50 in order of seniority. Tomorrow, day after, and Friday. We'll be releasing a advanced list also, or from commencing from 20th. There are quite a few hale CPCs where the stays have been granted. The suits have been stayed. So letters have been received from the PDJs of different districts saying that ಮುಂದೆ ಹೋಗ್ತಾ ಇಲ್ಲ, ನಮ್ಮ ಲೆಟರ್ ಬರ್ತಾ ಇದೆ 10 ವರ್ಷ 5 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ, ನೀವು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಅದಕ್ಕೆ ತಗೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ ಹಳೇದೆಲ್ಲ ಸ್ಟೇ ಇರೋದು ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ ಫ್ರಮ್ 20th. ನಾಳೆದು ಎವ್ರಿ ಡೇ 50, 50, 50 ವಿಲ್ ಪುಟ್. ಸೊ ಫೈಲ್ಸ್ ಎಲ್ಲ ತೆಕ್ಕೊಳ್ಳಿ.
orders. 1, Shivraj Balloli.
Your Lordship, the plaintiffs have taken the NOC, my Lordship, and we have filed the memo for retirement. Hence, kindly names be deleted.
The memo of retirement dated 26/11/24 has been filed, which reads as under. Learned counsel for the petitioner, along with the said memo, a copy of the no objection wakalatnama with the signature of respondent number 2D. Petition number 2D, na? R2D and ಬರ್ದಿದ್ದೀರಲ್ರಿ. You appear for petitioner or respondent?
Plaintiff, petitioner.
ಮತ್ತೆ ವಕಾಲತ್ನಾಮ ಅಲ್ಲಿ R2D ಅಂತ. Petition number 2D is being produced. It is submitted that petition number 2D was representing all the petitioners. And as such, the file has been returned. The petitioner has, the counsel for the petitioner has no instructions. Accepting the said memo, Shri Shivraj Balloli is discharged from the matter. He is permitted to retire and he is discharged from the matter. Registry that print the names of the petitioner and relist on 29th. If no appearance is made by then, the petition will be liable to be dismissed for non-prosecution.
Please, ma'am.
2, Jagdish Patil.
This is the wiki. They are the complainants before the deputy commissioner, your lords, against the grant of land grant.
Yes.
Lords, that in
No
the
such address at.
yes, your lords, that in the annexure F, your the impugned order they have mentioned themselves as the resident of Sirgaon. In page 63, your lordship.
60?
63, your lordships, impugned order, where they have made a complaint against us. They have nowhere concerned to the properties. All are resident of Sirgaon Taluk, Hukkeri district, Belgaum. Now we issued the notices on the same address.
60.
Now it has been returned with to sender, your lord. Such addressee at Sirgaon. No such addressee.
ಏನ್ ಮಾಡೋದು ಪೇಪರ್
Allah,
ಪಬ್ಲಿಕೇಶನ್
they are the complainants, your lords. Actually, they are not necessary parties because they made a complaint against the land allotted to us in the regularization committee.
notice issued to respond number 4 to 7. He is returned with the endorsement, inverted commas, no such address at Shirgaon. Hence returned to sender, inverted commas close. Shri Jagdish Patil and counsel for the petitioner submit that the address of respond number 4 to 7 is furnished as per the address furnished by them in proceeding number rb.lnd.ap.02 stroke 2001-02. And he further submits that apart from the said address, the petitioner does not have any other address of respond number 4 to 7 and is unable to trace out any other particular address. This is not a stray case. There are several matters which come up before this court where proceedings are initiated before administrative and quasi-judicial authorities where the complete postal address is not furnished,
Yes, sir.
resulting in a lot of time being wasted by this court and other courts in issuing and reissuing summons. It is therefore required for the concerned authorities to insist on the complete postal address being mentioned in any proceedings which are filed before the same is taken on record. Just mentioning resident of a village or a taluka would not serve any purpose. In that view of the matter, the Chief Secretary is directed to look into this aspect and issue necessary instructions to all administrative and quasi-judicial authorities to mandate that whenever any proceedings are filed, the complete postal address is furnished by such
Yes.
person filing it, as also the complete postal address of the person against whom it is filed. Learned AGA is directed to bring the above to a notice of the Chief Secretary, Government of Karnataka. Para. In the present case, the address provided by the petitioner of respond number 4 to 7 being that provided by them before the Deputy Commissioner and the petitioner being unable to secure any other address, there would be no purpose in issuing further notices to the very same address. It should again get returned unserved. In that view of the matter, and also take into consideration that respond number 4 to 7 were complainants,
Yes, sir.
and the state can well represent their interest before this court. So notice to respond number 4 to 7 is dispensed with. The relist on 29th January to enable the Chief Secretary to place on record the steps taken in furtherance of the above directions. ನೀವು objections file ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ. Yes, sir.
And you can take the interest and ಹೇಳಿ objections file ಮಾಡಿಲ್ಲ.
No, your lordship.
In the meanwhile, statement of objections to be filed by the learned AGA.
Yes, sir.
Records ಬೇಕಾ?
Not necessary. ಬಂದಿದೆ.
ಬಂದಿದ್ಯಾ? Yes.
Yes, sir. 3, Ganapati Shastri, SC Karnataka.
Appear for the petitioner in the connected matter, Millets. I'll amend the cost title in 2 days, Millets.
Mr. Kadakatti,
SC Karnataka.
P1A ga. Notice to P1A. Amendment of cost title by advocate for R3. 31/2020. Who is for respond number 3? Mr. Vigneshwar Shastri ಯಾರ appear ಆಗ್ತಾರೆ ಇಲ್ಲಿ? ಇಬ್ರ ಹೆಸರು
Usually SD Kadatkatti appears in this matter.
that is for the petitioner, for respondent Vigneshwar Shastri ಅಂತಿದೆ.
Yes, Patil. Yes, Patil.
KS Patil.
Yes. Yes.
KS Patil. Registry is direct print the name of Shri AS Patil along as that appearing for respond number 3 and delete the name of Shri Vigneshwar Shastri as that appearing for respond number 3. None appears for the petitioner. If none were to appear for the petitioner, the petition would be liable to be dismissed for non-prosecution. None appears for petitioner on the next date. 3.1, that counsel for the petitioner. Process fee.
Process fee will pay during the course of the day, my lords.
Submit that the process fee and copies would be furnished during the course of the day. And she seeks for 2 weeks' time to file necessary application in respect of the legal heirs of deceased respond number 4 and 9 on record, as also amended petition file file madidira,
Yes, my lords.
as also to carry out payment of the cost title. Relist on 29th January.
Interim order may kindly be extended.
Interim order earlier granted is extended till next date of hearing.
Great.
ಇವತ್ತೇ carry out ಮಾಡಿ ಇವಾಗ.
4, Sadiq Goodwala. AB Patil.
Carried out the amendment of cost title today itself, Your Worship.
Memo of retirement filed by R13. R13 ಯಾರು? Ganapati M. Bhatt. Ganapati Bhatt. Why is only filing for R13?
ಕೇಳತ್ತಾರ ನೋಡ್ರಿ ಗಣಪತಿ ಭಟ್
Fair memo for retirement.
R5
Fair memo for retirement.
R5 ಎದಿರಲ್ಲಿ ಗಣಪತಿ
You have filed for
R5
R13.
ಎದಿರಲ್ಲಿ ಇದ್ರಾಗ
ಗಣಪತಿ ಭಟ್ appear ಆಗಿದ್ದಾರೆ.
ಇಲ್ಲ
The memo dated 15/2/2022 has been filed by Shri Madan Mohan
R5,
M. Kannur, seeking permission to retire from the matter. Shri Ganapati M. Bhatt has entered appearance for respond number 13. As such, the memo of retirement is accepted. Shri Madan Mohan M. Kannur is permitted to retire from the matter. He is also discharged from the matter. WP 665 ಏನು DNP ಆಗಿದೆ. 4.1 ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ? 2.1 learned AGA seeks for and is granted 2 weeks time to secure the records. These are not secured by next date. ಯಾವ respondent?
for R13 ಅವರೇ ಹಾಕಿರೋದು ಈಗ ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್. ನೀವು R5
Respondent number 3 shall be personally present before this court. Relist on 29th January.
R5, R7, R13, R8.
5, Ganapati M. Bhatt.
I'm for petition. Please 10 days to furnish correct address of
Also
this.
for the petitioner, respond is granted 10 days time to furnish the correct and current and proper address of the unserved respondents.
Please.
As also to make payment of the process fee and furnish copies. If needful is done by 24th January, registry is directed to issue notice to the unserved respondents returnable by 21st March. If needful is not done by 24th January, relist on 29th January for dismissal.
Obliged, my lord.
6. Raviraj C. Patil.
Mr. Raviraj Patil.
Raviraj C. Patil.
None appears for the petitioner today also. A perusal of the order sheet indicates the absence of the petitioner on last several occasions. Necessary application to bring the legal representative of deceased petition number 1 has also not been filed. If none were to appear for the petitioner on the next date of hearing, petition would be liable to be dismissed for none were to appear for the petitioner on the next date of hearing and or necessary application not filed by next date of hearing, the petition will be liable to be dismissed for non-prosecution. Relist on 29th January.
7. P.S. Sankti, Biswaraj Mekki.
My lord, appearing for respondent number 6 and 7.
Yes. Respond number
6 and 7.
Mr. VP Kulkarni is appearing for 5 and 7, 5 to 7. Ante there.
NOC ಬಂದಿದೆ 6 and 7.
Kumar has entered appearance for respond number 5 and 6 and 7. As also Shri DM Manjunath has entered appearance for respond number 5. Hence registry is directed delete the name of Shri VP Kulkarni as that appearing for respond number 5 to 7. As also the name of Shri K. Raghavendra Rao and V. Vidya as that appearing for Kevator respond number 5. Where is Mr. Manjunath? Here.
6 and 7. Anil Kumar, 6 and 7.
6 and 7, I think.
Anil Kumar.
DM Manjunath and Praveen Raikote.
Praveen Raikote.
Raikote, you are on mute. Unmute, Madi.
I appeal for respond number 5.
Is there some objection on your wakalatnama?
Lord, your lordship have directed deletion of the other advocates who are appearing. Lord, only, Lord, the objection is that I have not obtained any no objection. Therefore, Lord, my wakalat may be kindly accepted.
Office objection as regards the wakalatnama filed by Shri Praveen Raikote is overruled. The wakalatnama is taken on record.
Please.
Yes. Ella pleadings complete, huh? Pleadings are complete?
Objection not.
Pleadings are not complete. They want a mandamus, my lord, directing the regional commissioner to consider their appeal.
Mandamus 2010 in the act pending.
Yes, yes, my lord. Therefore, my lord, I am submitting.
What happened to the revision petition?
Today, I have no information. I am told, my lord, it is still pending. But, no
After
updates.
14 years.
No updates are available, my lord, of the revision petition.
Yes, Mr. Anil Kumar.
Well, 2 weeks time will be granted, my lord. I will seek instructions, my lord, about presentation.
Learned AGA as also the councils are directed to obtain instruction and make the submission as regards the status of the revision petition filed by the petitioners. Relist on 29th January.
Review petition, my lord, reject ಆಗಿದೆ ಇದರಲ್ಲಿ ಹಾಕಿದ್ರು. My lord, division commissioner office in Bang, Gulbarga, my lord, rejected.
Revision petition is.
Yes, rejected.
Stating that, my lord, this is not,
My lord,
they are not having jurisdiction.
page number.
Ink page 90, my lord, annexure
90
G.
page.
Consider the revision petition ಅಂತಾರೆ ನೀವು ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ರಮೇಶ್ ಸಂಕಟಿ 90
Page number
90, my lord.
ಇದು endorsement as regards what?
They have no jurisdiction, my lord, because of that revision petition is not accepted by the regional commissioner.
Sankti, in prayer, you consider the revision petition was already rejected. We are asking for a Mandamus to consider the revision petition. Never produce revision petition.
I will verify and I will submit 2 weeks time. I can leave it. 2 weeks time.
8 SM Kalbat.
R3A is dead.
They have filed a memo for reporting death. We'll take steps. We'll take necessary.
R3B has died.
R3
B has died. Illa. Advocate for B, my lords. Advocate for R3A has filed this memo. That is there.
Your R3A to E. Memo
My lords, on 29/1/2024, my lords, I filed a memo.
R3C ಗೆ retirement memo ಹಾಕಿದ್ದೀರಾ?
Please, my lords. On 29/1/2024, R3D and E memo in respect of R3D and E was filed.
D and E.
Yes, my lords.
ಮತ್ತೆ ಇನ್ನ ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲದಕ್ಕೂ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
In fact, my lords, on 12/2/2024, this honorable court has accepted the memo in respect of R3D and
3B
E.
has expired. Note sheet ಸರಿಯಾಗಿಲ್ಲ. Where counsel for respondent number who appears for respondent number 3A to E has filed 2 memos of retirement. One in respect of respondent number 3D and E, which reads as under. And the other as regards respondent number 3C, which reads as under. Accepting the reasons stated in the aforesaid memos and the submission of Sri Chetan Monoli, the said memos of retirement are accepted, is discharged from the matter. Registry is directed to print the names of respondent number 3C, 3D and 3E in the cause list. If none were to appear for them on the next date of hearing, the matter would be taken up for consideration on the basis of submissions made by the other counsels. Sri Chetan Monoli submits that respondent number 3B has also expired on
17/1/2023.
Legal heirs yaru?
Lords, in fact, I asked, but my party is hospitalized. In weeks, my lords, if I get, my lords, I'll furnish to him.
He submits that given a week's time, he will furnish the details of the legal heirs of respondent number 3B to the counsel for the petitioner, who in turn seeks for 2 weeks' time to file necessary application. Relist on 4th February.
Please.
9 BV Somapur.
A week's time, please. For compliance of the.
Counsel for the petitioner seeks for and is granted 10 days' time finally to comply with the office objections. If the same is not complied by 27th January, the petition will be liable to be dismissed for non-prosecution. Relist on 30th January.
Please.
10 AC Chaglabi, SP Dodgauda.
During the course of the day, I will
Counsel for the petitioner submits that given 3 days' time, he'll make payment of necessary process fee in respect to unserved respondent number 3A. If process fee is paid by 17th January, registry is directed to issue notice to unserved respondent number 3A, returnable by 19th March. If needful is not done by 17th, relist on 22nd for dismissal.
11 case
One
party.
nimsham. Shri SR Egde and PK Sannimanganor have entered appearance for respondent number 3. Registry is directed to delete the name of Shri FD Dandin and SJ Patil as that appearing for respondent number 3. Relist also. Yes.
11 case party.
Please, ma'am. My lord, office has raised the objection with regard to the IA, my lord, for the bringing the legal representative of deceased respondent number 1, my lord. My lord, the death is reported before this honorable court in the year 2022, my lord. My lord, we applied for the death certificate of the respondent number 1, my lord, but that document is not provided till today, my lord.
During the pendency of the above matter, respondent number 1 was reported to be dead by the counsel for respondent number 1. In furtherance thereof, IA number 1 of 22 has been filed by the petitioner to bring the legal representative of deceased respondent number 1 on record. Registry has raised an objection thereon that the date of death and the death certificate have not been produced. The submission of learned counsel for the petitioner is that it is only on account of the submission made by the counsel for respondent number 1 that he came to know about the death of respondent number 1, and despite attempts being made, the death certificate has not been secured, could not be secured.
Please.
In that view of the matter, the office objection raised on IA 1 of 22 is overruled. Issue notice on IA 1 of 2022, returnable by 20th March 2025. Process fee and copies to be furnished by end of day 17th January, failing which IA 1 of 22 shall stand dismissed automatically.
During the course of the day.
During the course of the day.
12, HN Tharigon.
For the respondents.
The earlier Malad, the honorable court allowed the writ petition. At that Malad, the respondent prepared writ appeal. In the writ appeal, Malad, the writ appeal allowed and remand the matter. Malad, the for weeks time Malad to file Malad the amendment petition.
Counsel for the petitioner seeks for and is granted 1 week's time finally to file the amended cost title and carry out amendment.
Yes.
If needful is not done by 21st January, the petition will be liable to be dismissed for non-prosecution, relist on 30th January.
Please.
13, Chetan Munnoli.
Kindly pass over.
Pass over.
14, SL Matti.
1 week time may be granted to. Weeks time may be granted to.
Counsel for the petition seeks for a week's time. Needful is not done by 17th. If needful is done by 17th, issue notice returnable by 25th March. Not done by 17th, relist on 23rd for dismissal.
15, Umesh Ainapur.
Petitioner, my lord, challenging that.
First payment madidira.
Lord, kindly waive off the for recalling the
coordinate bench has imposed cost. You will have to pay cost.
The next time, please. But I informed to the client, my lord, but.
What is this matter?
Lord, the investigation officer, my lord, wrongly mentioned the offending vehicle number at charge sheet, my lord. My lord, that's why, my lord, he has filed the application for call the evidence, to give the evidence. Investigation officer should come and enter into the evidence witness box. My lord, application has been rejected. Only on the ground of, my lord, here is mentioned that, my lord,
why was this cost imposed?
Lord, recall, it was one time dismissed for non-prosecution, my lord.
Then you please pay. If you don't pay, then this will also go.
Please.
Again, it will get dismissed.
Next week, my lord, I will pay.
Counsel for the petitioner seeks for and is granted a week's time to comply with the order dated 18/12/2024. If the order is not complied by 17th, the petition would be liable to be dismissed for non-prosecution. Relist on 23rd January.
16, BB Somapur.
Memo for withdrawal of the
Petitioner is before this court seeking for the following leave. Learned counsel for the petitioner has filed a memo dated 7/1/2025, signed by the counsel for the petitioner, which reads as under. Accepting the said memo, petition is dismissed as withdrawn.
Yes, please.
17, Prithvi KS.
Lords, respondent number 5, my lords, is a formal party.
Not a contest.
Counsel for the petitioner has filed a memo dated 7/1/25, signed by the counsel for the, a memo dated 7/1/25 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the said memo, notice to respond number 5 is dispensed with as the sole risk, cost and peril of the petitioner. It is made clear that respond number 5 shall not be bound by any orders passed in these proceedings.
Contesting, my lords, respondents have appeared, my lords. Respond number 1 to 3. Who are the plaintiffs?
Ashok Naik.
Ashok Naik.
Yes, my lord.
Yes, serial number 17.
Yes, my lord.
My
Yes,
Ready?
my lord. I am 1 to 4, my lord. Next week, my lord.
In
Kindly
that
be
you
next week, my
have
lord.
no requirement to make payment of process fee in respect of respond number 5. At the request of counsel for respond 1 to 3 na 1 to 4 ah?
1 to 4, my lord.
You will appear for 4 also.
Yes, my lord.
Wakalat file madidira?
Yes, my lord.
Shri Ashok Naik, A. Naik, submit that he has filed Wakalatnama for respond number 4 also. Registry to verify, and if such Wakalatnama is filed, to print his name as that appearing for respond number 4. At his request, relist on 22nd January.
Interim order may be
Please,
extended.
Interim order earlier granted is extended till next.
Please.
It is
Please,
made clear that no further adjournment would be granted.
18.
Please, my lord.
AP Nesargi.
My lord, a week's time may be granted. I will
And for the
comply the
respondent
officer.
number 1, my lords.
You have not filed acknowledgement for having served the counsel for the respondents.
I will comply, sir. Week's time may be.
Stay there.
Stay there.
And why are you not serving? You are not purposely serving then.
Notice is served. Notice sent by this
serve
court.
it on the counsel for respond ಅಂದ್ಮೇಲೆ ಯಾಕೆ serve ಮಾಡಿಲ್ಲ?
Or vacation, they were on vacation.
ಏನ್ ಎಷ್ಟು ದಿನದ ವೆಕೇಶನ್ ಇದೆ? ಯಾವ ಫೈಲ್ ಆಗಿದೆ ಇದು? 17 January 2024. ಒಂದು ವರ್ಷದಿಂದ ವೆಕೇಶನ್ ಇದೆಯಾ?
ಏಪ್ರಿಲ್ ಒಳಗೆ ಸ್ಟೇ ಆಗಿದೆ.
ಆವಾಗ್ಲಿಂದ ವೆಕೇಶನ್ ನಡೀತು.
ವೆಕೇಶನ್ ತಗದ್ದು ಸರ್.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ. ಹಿಂಗೆಲ್ಲ ಹೇಳಿದ್ರೆ
ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
We'll have to pass orders on that submission.
ಸರ್ವ್ ಮಾಡಿಲ್ಲ. I'll
Don't
serve.
make those kind of submissions. Why should we extend the interim order?
The preliminary decree was not passed by the trial court, though application was more in view of the change in the
Interim
law.
order when you are not serving. Automatically vacate ಆಗಿದೆ.
ಅದು ಐತೆ.
22/2/24 order ಅಲ್ಲಿ ಹಂಗೆ ಇದೆ. There is no interim order to be extended.
Application was moved before the trial court in view of the change in the law. The one more requesting to
Counsel.
draw one more preliminary decree.
ನೀವು if you don't serve the counsel for respondents, automatically
ಅದು
vacate
automatic.
ಆಗತ್ತೆ ಅಂತಿದೆ. ಇನ್ನ ನೀವು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಒಂದು ವರ್ಷ ಆದ್ರೇನು ಹೋಯ್ತು interim order. Counsel for the petitioner is still not served. The counsel for the respondent before the trial court. In view of the order dated 22/2/24, the interim order had stood automatically vacated. Relist on counsel for the petitioner seeks for and is granted 10 days time to comply with the other office objection and make payment of necessary process fee. Relist on 29th. If needful is not done by then, the petition would be liable to be dismissed for non-prosecution.
May kindly be kept for final hearing. Final hearing. Finally be, may kindly be kept for a final hearing.
10 days ಕೊಟ್ಟಿದ್ದೀವಿ. Final hearing ಎಲ್ಲಿ ನೀವು process fee ಕೊಡಲ್ಲ, service
I'll
ಮಾಡಲ್ಲ.
pay, sir. I'll pay.
Compliance ಮಾಡಿಲ್ಲ. Interim order ತಗೊಂಡು ಕೂತಿದ್ದೀರಾ ಅಷ್ಟೇ. We won't encourage that. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾಗ ನಿಮ್ಗೆ ಹಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ?
In view of the change in the law, my share is increased. So I moved the application before the trial.
First do what you are required to do.
Please, my.
If you don't do the procedural thing, then your merits will go. Merits ಯಾರು ಕೇಳಕ್ಕೆ ಇಲ್ಲ ನೀವು ಇದೆಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
19 ಜಿಯಾಗೆ ಚಿನ್ಮಾಟ್.
There is one office objection, my lords, with respect to prayer. Prayer is not clear and specific ಅಂತ ಹೇಳಿ. My lords, my prayer is, my lords, to consider the representation, that is annexure H, which is at page number 94, my lords. To enter the names of petitioners in the CTS, my lords, before the ADL.
I think the submission of the counsel for the petitioner office objection at serial number 14 is overruled.
My lords.
They sought for a Mandamus, your lordship, directing.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the representation dated 2024 at annexure H submitted by the petitioner to respondent for causing the entry of the name of the petitioners in respect to CTS number 128 situated at ward number 3 Basavana near Old Bus Stand Hubballi has not been acted upon.
Please.
Whenever any application and or representation may lenga agata pa idu application submit ಮಾಡಬೇಕು. How can they act on a representation? Name change ಮಾಡಬೇಕು ಅಂದ್ರೆ entry ಮಾಡಬೇಕು ಅಂದ್ರೆ there is an application. Application ಜೊತೆ ಎಲ್ಲ documents file ಮಾಡಬೇಕು.
I'll submit with the application, my lords.
The petitioner has only submitted a representation for causing the entries of the name of the petitioners. No application supported by necessary documents has been filed by the petitioner. As such, no mandamus can be issued directing the respondents to act on the representation, reserving liberty to the petitioner to file necessary application.
There was a P&SC case, my lords. According to
application, file necessary application accompanied by the necessary documents. The petition stands disposed. As and when the application is filed, the respondents are directed to act on the said application within the period prescribed under the Karnataka Sakala so and so Act.
In page 98, Your Lordship, they have stated, ಈ ಅರ್ಜಿಯ ಜೊತೆ ನಾವು ಈ ಒಳಗಾಗಿ ನಿಮ್ಮ ತಮ್ಮ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ದಿನಾಂಕ 29/11/2022 ಜೆರಾಕ್ಸ್ ಕಾಪಿ PR ಕಾರ್ಡ್ CTS ನಂಬರ್ ಮಾನ್ಯ ಪ್ರಧಾನಿ 98, Your Lordship, page number 98. 98.
In the last page of the representation. Documents we have produced, my lords, but
where is the application? 29/12/22.
But in the petition, my lords, we have not produced application, Xerox copy of the application. But that we mentioned in the representation, my lords, that we have submitted the application with the records.
The grievance of the petition so and so. The submission of learned counsel for the petitioner is that the said representation was made in furtherance of the application submitted on 29/12/2022. If an application had been filed on 29/12/2022, it was required for the respondent to act on the said application and either accept or reject the application within the time prescribed under the Karnataka Sakala so and so. The same not having been done necessitated the filing of the above representation dated 23/2024, which is also not been acted upon despite lapse of time. In that view of the matter, I pass the following order. Writ petition allowed and Mandamus is issued directing the respondent to consider the representation dated 23/2024 at annexure H and the application dated 29/12/2022 filed by the petitioners within the period of 30 days from the date of receipt of a copy of this order.
Please,
20 FE part Pallavi Pacha.
Service agila learned AG accepts notice for response.
My lords, I've complied, my lords, after the last date, I've complied with the office objections.
Ishtondidave 1934 age of petitioner, pin code.
My lords, and serial number 35-3, my lords, the objection raised is that the petitioner number 3's name is not forthcoming in the endorsement. Only the petitioner number 1 and 2, my lords, they gave a representation, and therefore, my lords, they're all brothers who are joint owners, my lords, of this property. Therefore, that objection may kindly be overruled, my lords.
If you give your address like this, resident of Kukanur, Taluk Shirati, District Gadar, how are we going to find them? New amel one letter and our cursor reach agala. Postal address is required to be given. Pin code enu illa.
During the course of the day, my lords.
Registry has raised the objection as regards the addresses of the petitioner mentioned in the cause title. A perusal of the address indicates that each of the petitioners have been mentioned to be resident of Kuknur village, Shirati Taluk, Kuknur village, Shirati Taluk, Gadag district. The said address is not the complete postal address. Registrar Judicial is directed to issue necessary instructions to all concerned to clearly and categorically raise objection as regards the address of the petitioners if the complete postal address is not mentioned in the cause title. Counsel for the petition seeks for and is granted a week's time to comply with the office objections and furnish the correct and proper postal address of the petitioners. Relist on 21st January.
21, Pavan Doddati.
Registry has asked to me to pay my lord's deficit court fee of 300. 200 is already paid. Today, my lords, I have paid 100 rupees. So office objection insofar as serial number 5, it may be overruled. And insofar as 17, my lords, respond number 6, who is the purchaser, I had made him as party before the assistant commissioner. Whereas revision was filed by the contesting respondent number 5. He had not made him as party. And I have accordingly made him as party here since I had made him as party before the assistant commissioner. So office has raised objection there. Why he is made.
Counsel for the petitioner submit that the respondent number 6 is the purchaser of the property and is therefore a necessary party. Accepting his submission, office objection at serial number 17 is overruled. Counsel for the petitioner submit that the deficit court fee has been paid.
Please.
Registry to verify. Yes.
Yeah, request for tomorrow, my lords, there is emergency.
Your theory.
Password. Kindly pass.
Password.
22, Harshavardhan, Empire.
Emergent notice may be issued, madam. Please return. We will also take hands.
For furnishing process fee.
We will pay, my lord. It is second time. We will also take hand summons for R6 only, my lord.
Addressee not in the village. Yella ide problem. Very village address, village ಹೆಸರೇ ಕೊಟ್ಟಿದ್ದೀರಾ?
We will also take hand summons, my lord.
Gajaminal village, Bailongal Taluk. ಹೆಂಗ್ ಸರ್ವ್ ಆಗುತ್ತೆ ಇದೆಲ್ಲ? ಎಲ್ಲ ವಾಪಸ್ ಬರುತ್ತೆ. ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಏನು ನಿಮ್ದು ಹಂಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ. ರೆಸ್ಟ್ ಆಫ್ ಹಣಭರತಿ ವಿಲೇಜ್ ಬೈಲೊಂಗಲ್ ತಾಲೂಕು. ಒಂದು ಲೆಟರ್ ಕಳಿಸಿ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗೆ ಹೋಗುತ್ತಾ ಅಂತ. There's no point in issuing emergent notice. Again, it will get returned.
We will take hand summons, my lord. We will serve.
Correct address ಕೊಡಿ. This will go on pending for another 5 years for that reason. And counsel for the petitioner seeks for and is granted 10 days time to furnish the current and proper postal address of both the petitioners and respondent number 6. As and when the said address is furnished, registry is directed to cause entry of the same in the CIS. If the correct and proper postal address of respondent number 6 is furnished, registry is directed to issue notice to respondent number 6, returnable by emergent notice, returnable by 25th February. But petitioner is also permitted to take out hand summons on respondent number 6 and file affidavit of service in relation thereto. Please.
23, Praveen Kumar Kulkarni. Praveen Kumar Kulkarni.
Paso.
24, Ian Hosmane.
Week time, my lord, since.
Counsel for the petitioner seeks for and is granted a week's time to comply with the office objection. Relist on 23rd January.
25, Jagdish Patil.
This matter of filed occurs for 2, 3 and 4, my lords.
2, 3 and 4. One ಗೆ ಯಾಕೆ ಹಾಕಿಲ್ಲ? One ಗೆ?
I have filed occurrence.
ಯಾರ ಹೆಸರು ಹೇಳ್ಬೇಕು?
So senior name.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ. Yesterday only I filed the ವಕಾಲತ್.
So want to submit that he has filed ನೀವು?
For, I have filed it now, my lord, just.
Submit that he has filed wakalatnama for respond number 1. She wants to submit that he has filed wakalatnama for respond number 2 to 4. Registry to verify and print their respective names as that appearing for the respective respondents. Relist on
15th or 16th.
13th to 17th, this court
Yes.
will not be sitting. So
Yes,
it
sir.
will be on 20th.
Yes,
Please, ma'am.
26, Sriharsh, will open.
ಏನಾಗಿದೆ? Postal track record ಹಾಕಿದ್ದಾರೆ. Notice to respond number 1 to 3 was issued on 19/12/24. Awaiting service relist on 23rd January. Registry is directed to put up the postal track record by the next date of hearing.
Please.
The Registrar Judicial, the Additional Registrar Judicial is directed to issue necessary instructions to the concerned to put up the postal track record whenever any matter is listed before this court under the caption of awaiting service of notice or the like.
Interim order may be extended.
Interim order earlier granted is extended till next date of hearing. Respondent serve ಮಾಡಿದಿರಾ?
Please, my lords, we have served.
ಎಲ್ಲಿ ಯಾವ ಕೋರ್ಟ್ ಅದು?
ಅದು ಮುಡಲ್ಗಿ ಮತ್ತೆ
The memo dated 23/12/24 enclosing an acknowledgement of service of notice on the counsel for the respondents appearing before the trial court is taken on record.
Please, ma'am. Oblige.
27, Sadiq Kanvi.
My lord, these matters, my lord, a batch of petitions have been disposed with regarding to wherein, my lord, this honorable court has, insofar as no conference motion is concerned. With the same observation, this petition shall be disposed of, my lord. There was an interim order not to precipitate. Now, in view of that date having been lapsed, my lord, this honorable court has given liberty to the members to move afresh and thereafter to proceed further.
Where is Mr.
ಇಲ್ಲ ಅದ್ರಾಗ ಲಾಸ್ಟ್ ಟೈಮ್ನು ಬಂದಿದ್ದಿಲ್ಲ ಅವರು ಅದಕ್ಕೆ ಸೊ ದಟ್ ಆನ್ ಅರ್ಲಿಯರ್ ಬೆಂಚ್ ಡಿಡ್ ನಾಟ್ ಪಾಸ್ ಅನ್
ಅಂದ್ರೆ ಯಾಕೆ ಅವ್ರು ಬೆನಿಫಿಟ್ ಹಾಕ್ಬೇಕು?
ಅಲ್ಲ ದೇ ಆರ್ ಹ್ಯಾವಿಂಗ್ ದ ಬೆನಿಫಿಟ್ ಆಫ್ ಎನ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಅದಕ್ಕೆ ಅಲ್ಲ ಇಫ್ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ವೇಕೇಟೆಡ್ ಮೈ ಲಾರ್ಡ್ ದ ಮೆಂಬರ್ಸ್ ವಿಲ್ ಹ್ಯಾವ್ ನೋ ರೈಟ್ ಟು ಅಗೇನ್ ದೇ ಹ್ಯಾವ್ ಟು ಪ್ರೊಸೀಡ್ ಫ್ರೆಶ್.
ಅಪಿಯರೆನ್ಸ್ ಬೇಕು, ಕೌನ್ಸಿಲ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗಪ್ಪ?
ಕೈಂಡ್ಲಿ ಪಾಸ್ ಫಾರ್ ಮೈ ಲಾರ್ಡ್ ಐ ವಿಲ್ ಐದರ್ ಇಂಟಿಮೇಟ್ otherwise the lordship shall pass this order, similar orders ಅಷ್ಟೇ.
Petitioner is before this court seeking for the following reliefs. The subject matter of the above petition is covered by an order dated 18 December 2024 passed by a coordinate bench in WP number 107065 of 2024 and other connected matters. The said order would be equally applicable to the present petition. As such, I pass the following order. Writ petition is disposed of. Liberty is reserved for the respondents stroke members of respective Gram Panchayats to initiate the process in cases so required and as advised in accordance to the provision of the Gram Swaraj and Panchayat Raj Act and the rules thereunder and take suitable action in accordance with law. It is made clear that this court has not adverted to the merits of the matter. All questions are left open to be decided in appropriate cases, if any, while including the issue of maintainability and the locus as and when required.
One submission.
28,
With one
Arjun Swami.
one permission. Submission. Instead of covered ಅನ್ನೋ ಬದಲಿ identical case. Instead of covered ಅನ್ನೋ ಬದಲಿ identical case.
Covered ಬದಲು
identical case. So ಅಲ್ಲ for the our convenience
has been dealt with in an identical matter.
Here for the petition, let's office objection with regard to serial number 19 minutes. We had filed a IA for dispensation on 13/12/2024.
Along with the petition.
No, my lords.
Idu 1312 file.
Yes, my lords. First, we had filed writ petition. On the same day, my lords, IA was filed.
Typed copy to be described properly enidu.
There are minor office objection will comply during the course of the day.
Yes.
This is deemed conversion matter, my lords.
And AGA accepts notice for respondent number 1 and 2. He seeks for and is granted a week's time to obtain instructions and make his submission. Released on 21st January. In the meanwhile, office objections to be complied.
Great.
29,
Thank you for the petitioner. Office raised objection because I made a respondent number 6 as a party to the proceedings. Because now the amount has been deposited before him. My suit came to be dismissed, Your Lordship, that. Against that, I filed a regular appeal. In that, Your Lordship, I made an application for a stay. That is on 24/8/2024. Till today, no order has been passed. If the amount is withdrawn, Your Lordship, that the entire, my RA will become infectious. That's my contention.
Not make him a party in those proceedings?
No, Your Lordship. Before that, Your Lordship, he was not a party. Subsequently, in the RA, Your Lordship, that they have made an application, proposed anta badida.
Which is pending.
Yes, Your Lordship, it's pending.
Impleading application.
Impleading plus, Your Lordship, that the stay of order.
Learned counsel for the petitioner submits that respondent number 6, though not a party to the proceedings, an application for impleading respondent number 6 has been filed and is pending. And as such, respondent number 6 has been made a party to these proceedings. The said office objection is kept pending. Learned AGA accepts notice for respondent number
6.
Issue notice to respondent number
1 to 5.
To 5. Returnable by emergent notice returnable by 12th February. Counsel for the petitioner is also directed to serve the counsels for the respective counsels for respondent number 1 to 5 before the trial court and or the first appellate court and file an acknowledgement thereof before this court on or before 21st January 2025. Respondent number 6. Nimdu share estu?
The entire anta ke 1/3 anta kelidare.
1/3 of the amount.
Howದು 1/3.
The respondent number 6 is restrained from disbursing compensation amount on account of the acquisition of the land in survey number
79, 12 acres, 13 guntas at
79.
Measuring survey number 79.
13 guntas situated at
Hasinabi village, Lordship, the Badami Taluk.
See the Asinabi village of Badami Taluka.
Badami Taluk.
To an extent of 1/3 claimed to be the alleged share of the petitioner till the next date of hearing. It is made clear that the above order will not come in the way of respondent number 6 dispersing the 2/3 amount of the 2/3 of the compensation amount awarded. Process fee and copies to be furnished by end of day 9 January, failing which and failing the filing of acknowledgement of service on the counsel for the respondents, the interim order above granted will stand automatically vacated.
The petitioner to serve the copy.
Serve a copy or you? No.
Yak sir model
36. Sharad Patil.
Office objection, my lords, regarding annexure C, my lords, to be clarified. My lords, subsequently, my lords, I produced the net copy of the order sheet, my lords. Since, my lords, this petition is concerned, my lords, it is only a mercy petition.
Annexure C is to be clarified, and what is to be
My lords,
clarified?
net copy I have produced, my lords. Earlier, my lords, I had produced a certified copy. My lords, then, my lords, could not get the, due to urgency, my lords, then I produced the net copy of the order sheet, my lords.
Annexure C part ado.
Then my lord, certified copy till proceedings and till today proceedings. It is posted on 14/2/2025 my lords for attachment of the sale property.
Registry has raised an objection as regard the printout of the order sheet uploaded onto the website of
E-courts
the e-courts. An uploaded copy of an order file, an order uploaded into the e-court website is also a copy of the order. As such, I am of the considered opinion that no objection could have been raised as regards the non-production of the certified copy thereof. The issue of certified copy or otherwise would arise only if the said order is disputed by the other side. E-certified copy ಯಾಕೆ ತಗೊಳ್ತಾ ಇಲ್ಲ ನೀವು?
Since my lords, the property was attached by the.
E-certified copy ತಗೊಳ್ಬೋದಲ್ಲ, order copy.
I could have get it.
1 hour ಅಲ್ಲಿ ಬರುತ್ತೆ.
Sorry, my lord, sir.
ಈ ಇಶ್ಯೂನೇ ಬರಲ್ಲ.
Next
ಮುಗೀತು.
Next time I'll be careful.
In that view of the matter, office objection at 43(1) and 2 are kept pending. Yes, what is the issue?
My lords, this is matter, my lords, award passed by the Commissioner of Cooperative Society, my lords. Here, my lords, the petitioner had availed a loan. Since, my lords, he could not repay the amount, my lords, it was classified as an NPA. Then, my lords, EP was filed. My lords, EP.
The amount due yesterday.
My lords, 7,53,393, my lords.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
My lords, I'll deposit, my lords, the amount of the 50% of the amount, my lords, I will deposit before this.
By when?
My lords, within 4 weeks. My lords.
Where is the decree?
My lords, decree, my lords, execution petition only, my lords, page number 13, my lords. Page number 13, my lords may get it, my lords.
17th March, 756. ಇನ್ನ 2 ವರ್ಷ 17% interest. So that is another 17 into 7, that is another lakh of rupees.
8 lakhs.
9 lakhs ಆಗತ್ತೆ. Counsel for the petitioner submit that the amounts due as on date is about 9 lakh of rupees. And due to financial stringency, the petitioner could not make payment of said amounts. His submission is that given 4 weeks time, 50% of the said amount amounting to rupees 4,50,000 would be deposited. In that view of the matter, the arrest warrant.
Unless sale warrant, my lords, attachment of movable properties, my lords.
The attachment order dated?
My lords, 2/1/2025.
2/1/2025, passed in EP number
60 of 2022 minutes.
60 of 2022 by the Principal Senior Civil Judge and CJM Belgavi is kept under suspension. If the aforesaid amount is not paid by the petitioner to respond number 1 by 5th February, the above order of suspension will stand automatically revoked.
Please.
Relist on issue. ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದಾರಾ?
ಇಲ್ಲ. No minutes.
ಎಲ್ಲಿದು? ಬೆಳಗಾವಿ. Counsel for the petitioner is directed to serve the counsel for respond number 1 before the trial court and file acknowledgement of service thereof on or before 21st January. Issue notice to respond number 1 to 4, returnable by emergent notice returnable by the date February ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ 5/2. Process fee and copies to be furnished by end of day 8th January, failing which the interim order will stand automatically vacated.
Grateful.
31 Venkatesh Harvey.
Directed to
Valuation certificate and
yesterday, I have produced my lords, that valuation certificate and medical certificate. I have could not get the seal deed, my lord, because the parties left the village that because of the apprehension of the arrest, my lords. Within a week, I will that produce, my lords. Otherwise, seal deed, as per the my lords, that property is value more than 3,46 lakh, my lords. And execution, they are claiming 2 crores, my lord, 20 lakh. There's a medical center. My father is in bedridden and my Mother also last month she was died, my lord, due to the ill health, my lord. ಇದರಲ್ಲಿ 3 ಕೋಟಿ
ಎರಡು ಪ್ರಾಪರ್ಟಿ ಸೇರಿ 3 crores,
3 crores of 40 lakh, my lords. I have purchased on 2004, my lord, for 40 lakhs.
So this property can be brought to sale?
Yes, my lord, definitely.
Lord counsel for the petitioner has filed a memo enclosing the valuation report. ಇವ್ರು ಯಾರು ಇದು? Is he a registered government valuer?
This is the corporation registered consultant, my lords.
Registration number
Yes,
ಏನು
sir.
ಇಲ್ವಲ್ಲ Mr. Karvi?
But he is registered, my lords. I have.
ಎಲ್ಲಿದೆ registration number ಏನು ಇಲ್ಲ?
But he is ಅಲ್ಲಿ ಬಳ್ಳಾರಿ ಕಾರ್ಪೊರೇಷನ್ ಇಂಜಿನಿಯರ್ ಅಂತ ಹೇಳಿದ್ರು.
Is he a registered valuer?
Registered valuer, sir. Hiranna Swami Consultancy.
ನಂಬರ್ ಏನು ಇಲ್ವಲ್ಲ?
ನಂಬರ್ ಏನಿಲ್ಲ.
Registration number ಇರಬೇಕು. The valuation report said to be furnished by a registered valuer, indicating that the value of the property
3 crores 46 lakh
is 3,46,30,200. The submission of the learned counsel for the petitioner is that the total dues of the petitioner is rupees
2 crores 20 lakh, my lords. An
20,00,00,
execution petition, my lord, page number 60, my lord.
and the above property
2 crores 26 lakh
can be brought for sale. Can the above property can be brought for sale?
Yes.
To recover the due amount?
Yes.
Since the petitioner is at present unable to sell the property.
Please.
Due to the petitioner being preoccupied with taking care of his father who is hospitalized. In that view of the matter, the further proceedings, the arrest warrant.
Arrest warrant. Further proceedings statement.
Further proceedings.
Yes, yes, please.
ಆಮೇಲೆ ಸೇಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Please.
The arrest warrant issued by the 4th Additional District and Sessions Court, bracket Commercial Court Bellary in Commercial Execution number 630 of 2023, is stayed till the next date of hearing. The petitioner is directed to place all the original documents relating to the aforesaid property in the custody of the aforesaid court to enable the said court to initiate proceedings for sale of the said property.
Yes.
The pendency of the present proceeding before this court will not come in the way of the execution court bringing the said property for sale. Issue emergent notice to the respondent number 1 and 2, returnable by 11th February. Counsel for the petitioner is also directed to serve the counsel for the respondents before the execution court and file acknowledgement thereof on or before 21st January.
Please.
Process fee and copies to be furnished by end of day 8th January and acknowledgement to be filed, acknowledgement of service on the counsel for respondents to be filed by 21st January. Failing either of which, the aforesaid order will stand automatically vacated.
And complying. Meantime.
In the meanwhile, office objections to be complied with.
Serial number 30, my lord, I seek 2 days accommodation, my lord. 2 days accommodation, I'll have to make good the deficit court fee, my lord.
Deficit court fee, our objections.
And the rest other objections will be complied during the course of the day, my lord. Matter may kindly be posted on Monday.
2 days time.
Monday, my lord.
Relist on 10th January.
Please, lord.
33, Jaykumar S. Patil.
Happy for the
Mallikarjun.
request, my lord, sir.
Registry is directed delete the name of Sri Jaykumar S. Patil as that appearing for the petitioner.
The petition was dismissed for non-prosecution. I had filed an application to recall that order. That was recalled, Millets.
Filed by respondent number 3A to 3D.
Application filed for recalling was allowed by this honorable court. That order is sought to be recalled by this application.
No, I am not earlier advocate. I have filed no objection.
The only ground is this. I had given a copy of the application to
Let's the matter may have it on day after tomorrow. We'll argue the matter finally on merits.
The above matter having been dismissed for non-prosecution, the said order of dismissal came to be recalled by order dated 12/6/2024. It is to recall the said order that IS 6 of 24 is filed. Such an application not being maintainable, IS 6 of 2024 is dismissed, reserving liberty to the respondents to file necessary proceedings, which may be permissible if if thought fit. Released on 21st January for final hearing, it is made clear that no further adjournment would be granted. If arguments are not advanced by the petitioner will be liable to be dismissed for non-prosecution. If arguments are not advanced by the respondent, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner.
The records of the land tribunal may be, government advocate may be directed to secure.
LR. The AGA is directed to secure the records by then.
Please.
And make available the same for inspection to both the counsel for the petitioner.
Please.
34, Ravi Kumar, D. Kokakkar.
34.
12/2/21.
That's it. In this case, the matter was earlier filed in the principal bench. Thereafter, matter came here. These parties since 2005, until this application came to be filed, they received a notice from the assistant commissioner, wherein the present affidavit person who has shown to affidavit, he is shown to be dead. When he received all this communication, then they contacted. They didn't have any communication at all in the meantime, and in between Corona also intervened. But the fact of the matter is that he is shown to be dead, and the mutation was supposed to be changed on the strength of this order of dismissal. Thereafter, somehow they came to me there, and I have filed the application to recall the order dismissing for non-prosecution. Para 5 and 6 I have stated. They were completely in dark because they had no idea as to who they should approach after transfer of this. And it doesn't have a landline, mobile. That is the problem. Otherwise, I tried my level best.
Was shown to be dead.
Shown to be dead. In fact, he's alive.
Next, A.S. Patil for R3 was contesting.
So A.S. Patil, Veeresh B. Patil.
Insert the copy.
Who are the petitioners? Ali. Who are the Password? Password.
Please. Yes, Patil.
35, VM Shilvan.
Better.
So there is a delay of 157 days delay.
Recalling 1571 days.
But petitioners, LRs have filed this application, my lords.
Petitioner Jivantidav.
Lords, the matter was dismissed because the respondents were rival tenants, as the matter was dismissed for non-prosecution. But the petitioners on record, which have filed the application now, they are the LRs of the LR.
Did not take any action to bring their legal representatives on record.
Lords, the petition
14/3/2011 abated as against 4 and 7.
Lords, sole
Because
petitioner.
13 years ಆದ್ಮೇಲೆ ಬರ್ತಾ ಇದ್ದೀರಾ.
Sole petitioner died on 2/7/18, my lords. And thereafter.
2018 ತಾನೆ.
Please.
14/3/2011 abated against respondent number 4 and 7. 9/11/2011 against respondent number 11. Not a fit case.
Lords, but the sole petitioners, LRs have filed this application. Lords,
So
they are
what?
not having the
Our
knowledge.
LRs ಬಂದು ಹಾಕಿದ್ರೆ
When the respondents went to the land to disturb the person, at that time they got to know.
ಅದುವರೆಗೂ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳ್ಳೋದು.
ಅವಾಗ ಅವ್ರ knowledge ಬಂತು, then
Not
they
a
have
fit
filed this
case. Ask your
application.
senior to come, we'll dismiss it when his presence. 2011 to 2024, sorry. Pass over.
36, Sunil Desai.
Appear for the petitioner. I4 impleading
Who
application.
do you want to implead?
The joint director, Your Lordship.
Accepting the reasons stated in support of IA 1 of 22, the application is allowed. The joint director land records is brought on record as respond number
4, Your
4.
Lordship.
Learned AGA accepts, counsel for the petitioner to carry out necessary amendment, file amended cause title. Learned AGA accepts notice for respond number 4. Vakil and Tahsildar, private party. Mr. Santosh Attikatgi.
Santosh Hattikatigi.
None appears for respond number 2. If none were to appear for respond number 2 on the next date of hearing, the matter would be taken up for consideration on the basis of the submission made by the counsel for the petitioner and learned AGA. Considering that the matter is of the year 2010, released on 22nd January.
Please,
It's made clear that no further adjournment will be granted.
please,
If arguments are not advanced by the petitioner, petition would be liable to be dismissed for non-prosecution.
please, oblige.
7, Mallikarjun Swamy.
Impleading application.
Who is this 12 and 13? Any objections?
Formally, my objections, because it's not a personal litigation that is sought to be fought by them. A grant made in favor of the petitioner society is challenged by the villages. 2 other persons now want to come on record. Formal objections may be recorded and it can be allowed. Anyway, others are already on record, other villages.
IA 1 of 24 has been filed by certain villages of Alattaga village who are also opposed to the grant made and now set aside in favor of the petitioner.
Yes.
Other villages having already complained and they being on record, I am of the considered opinion that the proposed respond number, that the impleading applicants could also be brought on record. You are not filing any other additional objections.
On behalf of these impleaded respondents, I intend to file objections by next day.
In the 2010 matter, we won't delay it.
It's a detailed objections filed by them.
Your other people have already filed. There's nothing that you can file. More so on account of the submission made by the impleading applicants that they would rely on the objections already filed and they would not expand the scope of the petition. IA 1 of 24 is allowed. The impleading applicants are brought on record as respond number 12 and 13. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Statement of objection filed by Agide. Non-filing of objection to IA 1. In view of IA 1 of 24 being allowed, registry is directed to delete the note as regards non-filing of statement of objections to IA 1 of 24. Secure Agidya?
No,
No, Your Lordship.
And AGA seeks for and is granted 10 days time to secure the records. If the records are not secured by 29th January, respond number 1 shall be personally present before this court. On the records being secured, learned AGA shall make available the said records for inspection of both the counsel for the petitioner and all the respondents. Then inna edil bere jaasti ಇದೆ. Again, this complication ಮಾಡಿಟ್ಟಿದ್ದೀರಾ ಇದು. Registry is directed to print the name of Sri Chetan Munoli, Lokesh Hegde and Surbhi Kulkarni. As that appearing for respond number 6, 7, 9, 10,
11, 12 and 13.
11, legal 8, R8A2.
R8 has died, my lord. R8 has died.
As LRs of deceased R8.
The impleading 12 and 13, my lords, they have come.
12 and 13 are legal representative of 12 and 8.
11. One implementation is to come on record as R11, as LR of deceased R6.
R8.
R8.
Yes, Mr. Shastri.
R11 is LR of R8.
R8.
R10, 11, 12 and 13. What happens to 3 is abated?
It is abated.
It is.
Registry is also directed to print in the cause list that the petition has stood abated in respect of respond number, that the petition has stood abated in respect of respond number 3. What about 4 and 5?
Also abates. They are also no more.
What about 4 and 5, Mr. Shastri?
It has abated against them also.
They are also dead?
They are also, my information is that, my lord, the litigation started 30 years ago. Then they filed appeal.
Yenappa, 4 and 5 were dead, ante.
No, it was not reported. In fact, the notices were served on them.
For
They were not represented.
my information is all 3, 4 and 5 died, my lord. All 3, 4 and 5 died.
You are reporting death now.
Let me take it so.
Huh?
Your last may take it so. R3, 4 and 5 died.
3 to 5 have died.
Sri G.V. Shastri submits that respond number 4 and 5 have also expired.
No, it's not in their emulate, sir. It's an individual capacity. It's in the form of PI. So question of bringing LRs would not have.
Doesn't
When
arise.
counsel
There is
for
no
the
difficulty
petitioner
about it.
submits that there is no individual right of respond number 4 and 5 in respect of a list in the present matter, inasmuch as the objections had been filed earlier by them in public interest.
Yes.
In that view of the matter, there would be no requirement to bring the legal representative of deceased respond number 4 and 5 on record. Illar Dvaita, 1 and 2 state, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
Please.
Name of Sri RM Kulkarni also.
Registry is directed to delete the name of Sri RM Kulkarni as that appearing for respond number 4 to 10.
Name of senior also, along with.
Aitala.
ಅದಕ್ಕೆ ಅದೇ ಹೇಳಿದೆ.
It is
ಚೇತನ್ ಮುನೋಳಿ, ಲೋಕೇಶ್ ಹೆಗ್ಡೆ, ಸುರಭಿ ಕುಲಕರ್ಣಿ.
GB Shastri.
I am with always with them, my lord. Though my name is not shown.
G.B. Shastri, Chetan Monoli, Lokesh Hegde,
Is
and
them.
Surabhi Kulkarni.
Oh,
As that
is it?
appearing. So your Gellar
Everything.
is so jumbled up that
Yes.
you can't correct it. ಯಾವಾಗ ರೆಡಿ ಆಗ್ತದೆ? ಯಾವಾಗ ರೆಡಿ ಆಗ್ತದೆ?
29th records ತೋರಿಸಿದೆ ನಮಗೆ.
29th.
Prasad Patil.
No, sir. I filed an application for appointment of court commissioner, my lords.
Impleading application is still pending?
No, sir. It is allowed, my lords.
It was allowed.
IA number ಅದೇನದು?
They have filed one application for appointment of court.
22-113. ಮತ್ತೆ ಯಾಕೆ? ಯಾವಾಗ ಅಲೋ ಆಯ್ತು ನಿಮ್ಮ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್?
Reading application ಯಾವಾಗ ಹಾಕಿ?
ಯಾವಾಗ ಅಲೋ ಆಯ್ತು?
my lords, it was allowed on 24 May 2023, my lords, it was allowed on.
24/5.
Please, my lords.
ಅದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 ಅಲ್ವಾ ಆಯ್ತು. 3 and 4 ಯಾವಾಗ ಅಲ್ವಾ ಆಯ್ತು?
Lords, 3 and 5 are the 3 to 5 are the LRs of the deceased Sadashiv Gokhale.
When was that allowed?
Lords,
ಇಲ್ಲಿ ಅಲೋ ಆಗಿದ್ದೆಲ್ಲೂ ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ? What is the IA number, Raut?
Please.
Application number.
IA 1/2020. IA 1/2020.
2020. But that is for respond number 9.
Yes, sir.
ನೀವು ಇವಾಗ 3 and 4 as LRs of R2 ಅಂತ ಹೇಳ್ತೀರಾ? Santosh Raut for impleading applicant R3 and 4 as LRs of deceased R2.
please, my lords.
Dated 22/1/2013 ಅಲ್ಲಿ ಅಂಥದ್ದೇನು ಆರ್ಡರ್ ಇಲ್ಲ. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ ಏನು ಎಲ್ಲೋ ಆಯ್ತಾ ಇಲ್ವೋ?
Please allowed. IA number 1/2020 was allowed on 24/5/23.
IA 1/2020.
Order dated 23/11/2011. R2 having died, a memo has been filed to treat R3 and 4, not impleading. A perusal of the order sheet indicates that on 23/11/2011, a memo had been filed reporting the death of respond number 2 and treat respond number 3 and 4 as his legal representatives. In that view of the matter, the office note put up the appearance of the counsel, Shri Santosh B. Raut, as that appearing for impleading applicant R3 and 4 as LRs of deceased R2, while order dated 22/1/2013 is incorrect and contrary to the records. You will appear for 3 and 4.
That only proposed, that is respond number 9.
3 and 4 ಯಾರು?
Lords, already served, my lords. Sir, ಅವ್ರಿಗೆ notice serve ಆಗಿದೆ.
Notice 3 and 4 are the LRs of deceased
Shri Santosh B. Raut
Notice
submits that he does not appear for respond number 3 and 4, but appears for respond number 9, who had filed a impleading application which came to be allowed, wide order dated
24/5/2023.
24/5/23. In that view of the matter, registry is directed to delete the noting, inverted commas, Santosh B. Raut for impleading applicant R3 and 4 are LRs of deceased R2. ಇದಲ್ಲ ಇದು ಹಂಗಲ್ಲ ಬಂದಿಲ್ಲ ಅದೆಲ್ಲ ಹೊಡೆದಾಕಿ. The impleading application filed. ಇದು wrong. The impleading application filed by Mr. Santosh B. Raut has been allowed, and the impleading applicant has been brought on record as respond number 9. In the registry, correct the appearance of Sri Santosh B. Raut as that appearing for respond number 9. The noting put up by the registry that respond number 3 and 4 are LRs of deceased R2 by order dated 22/1/2013 is contrary to the records insofar as the date is concerned, and as such the registry correct the same set date as 23/11/2011. 3 served, 4 aitu, 5 6. 3 dismissed. 7 and 8 you are appearing, Mr. Patil.
Yes, Your Lordship.
Yes. Readings are complete.
Readings are complete. Now he has filed an application. Your Lordship may kindly
For
see the
appointment of
application.
Previous delete ಮಾಡಿ. Correct the appearance of Santosh Raut ಅಲ್ಲಿಂದ ಇರುತ್ತೆ. Yes, have you filed objections?
Your Lordship, not yet.
Appointment of commissioner. Disputed question of original name of the father of the deceased.
Father of the petitioner.
This, my lords, what has happened, my lords, in the last date of occasion, my lords, the respondents have raised an objection with regard to the name of the petitioner, my lords. That is the reason, my lords, before lordships, my lords, they have asked me to produce some original documents with regard to the original name of the petitioner, my lords. My lords, therefore, my lords, even, my lords, it is a mistake of the Talati, my lords. What has happened, my lords? His original name is Gundu Payana Patil, my lords. Instead of, my lords, he is recording as Massacre, my lords. My lords, in the local language, my lords, it was, my lords, he is originally belongs to Macha village, my lords. And in a local language, my lords, they were called as a Massacre, my lords. That is the reason, my lords, he was made an entry as a Massacre, my lords, instead of Patil, my lords.
How are Patil and Massacre one and the same?
My lords, that is the disputed question, my lords. For that reason, my lords, I have filed an applications to.
How will the Tahsildar?
Not the Tahsildar, my lords. Instead of Tahsildar, my lords, Talati he can also file a report, my lords.
Yenanta report file ಮಾಡಿ.
My lords, that is the, my lords, let him make an inspection, my lords, then he can file it application.
You file under RTI, get the document.
My lords, I have filed it RTI, my lords, but he has not, such name is not available. He is not, till today, my lords, he is not served any reply, my lords. My lords, as on the date of the notification, my lords,
when you say question of original name of the father of the deceased petitioner, andre, ಯಾವ document ನೋಡ್ಬೇಕು? Which document is to be referred to?
My lords, earlier, my lords, what has happened, my lords, his name is same, my lords, but instead of Patil, my lords, he put it as a Massacre, my lords.
That we understood.
Please, my lords.
But where do we find that? Which document would this Tahsildar or Circle Revenue Inspector or village accountant have to verify for this?
My lords, what has happened, my lords? The earlier, my lords, the Talati was used to made an entry as a Massacre, my lords. Originally, he belongs to the village called as Mache, my lords. So in local language, my lords, Massacre. Instead of that, my lords, Massacre. Like that, my lords, they were used to call, my lords, the petitioner, my lords. So therefore, my lords, the earlier Talati, which was he he made an entry as a massacre, my lords, instead of Patil, my lords.
You have repeated that 4 times.
Please, my lords.
We understood that.
Please, my lords.
But that entry has been made in which document?
My lords, in the RTC, my lords.
In the RTC?
Yes, my lords. Earlier RTCs, my lords.
Where is the RTC?
My lords, the RTCs are produced at annexure. My lords, at page number 11, my lords, annexure A. Those are the RTCs, my lords. Payappa Yellappa massacre, my lords. The father of the petitioner, my lords. This is petitioner, my lords.
Yes.
Payappa is the father of
So
the
what
petitioner.
more is to be seen when the name is shown there?
My lords, instead of massacre, my lords, that is what the question.
Which document has his name as Patil?
My lords, the Patil is in, my lords, the form number 7, my lords. Form number 7A.
Page.
My lords, the page. My lords, I request you lordships kindly turn to page number 64, my lords, the order of the Assistant Commissioner, my lords, page number 64 for a moment. There he mentioned this statement, Gundu Payana Patil Urf massacre.
64.
My lords. In the column, my lords, tabular column, my lords, serial number 1.
Gundu Payana Patil Urf massacre. So this is a report by whom?
My lords.
This is the order.
My lords, yes, my lords.
On the basis of a application filed by him.
Yes, my lords.
Claiming to be Uruf massacre.
Yes, my lords.
That's a very claim aito. Where is this is the application filed in, when was this application filed?
The application was filed. It's the KAT order, my lords. It runs at page number 66, my lords. My lords, these are the appeals have been filed under section so and so against a common order.
This is 7A.
Please, my lords. It is 7A.
77A. That is after 79.
Please, my lords.
You filed your grandfather is stated to have filed.
Yes, my lords.
He claims himself to be Patil and alias massacre.
Yes, my lords.
So you'll have to produce an independent document.
My lords, I have tried my all the level best, my lords, but I
You
could
don't
not
have the
find.
document, nobody can help you. We can't have a rowing inquiry of looking into what document to find out whether it's Patil or
My lords,
massacre.
earlier, my lords, even I tried, my lords, but till today, my lords, I could not get it, my lords. Even I approached to the Tahsildar, my lords, he has given an non-availability certificate, my lords.
Non-available and the ಏನ್ document inspect
My lords,
ಮಾಡಬೇಕು?
I requested him to produce a death certificate or something, whatever even the taxpayer receipts, whatever.
Counsel, that is your family.
Please, my lords.
You have to produce.
My lords, the
Or
only,
apply for, you don't know which document, you don't have any document. ಯಾವ document will the Tahsildar, will village accountant inspect?
I'll try one more time, my lords, if you lordships permit me to.
If we say give a certified copy of an order dismissing a petition,
No, my lord.
ಯಾವ್ದು ಕೊಡ್ತೀರಾ ನಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ? It is worse than a needle in a haystack. ಆಗಲ್ಲ ಇದು. Nobody, it's impossible for him to do any search. That application is not maintainable. If you want, you produce some document.
Please, my lords, one opportunity may kindly be.
We'll give you 10 days time.
Please, my lords.
It's a 2010 matter.
10 minutes, yes, my lords.
IA 1 of 24 has been filed seeking for appointment of the Tahsildar or the Circle Revenue Inspector or Village Accountant to be appointed as a court commissioner to ascertain the disputed question of original name of the father of the deceased petitioner. Firstly, a commissioner cannot be appointed to ascertain any disputed question of fact. In this case, the dispute is as regards the name of the father of the petitioner to be Gundu Payana Patil or Gundu Payana Masekar, Masekar. A commissioner cannot be appointed to carry out a rowing inquiry to ascertain the name of the father of the petitioner when it is required of the petitioner to produce necessary documents in relation thereto. Thus, I am of the considered opinion that the application IA number 1 of 24 lacks merit and is dismissed as such, reserving liberty to the petitioner to produce such documents as the petitioner may choose to establish the name of the father of the petitioner. Released on 29th January.
Please, minutes.
It is made clear that no further adjournment would be granted. If arguments are not advanced by the petitioner on that date, petition will be liable to be dismissed for non-prosecution.
Please, minutes. Wait.
39, Hemant Reddy Saukar. Hemant Reddy Saukar.
During the pendency of the above matter, the petition number 1 expired on
2021 minutes.
12/8/21.
Yes.
One illa.
Yes, missing.
12/8/2021.
I produced the death certificate.
Hence, IA 1 of 24 has been filed on 19/8/24 by the legal representative of deceased petition number 1 to come on record, accepting the reasons stated therein and being of the considered opinion that the right to sue survives. IA 1 of 24 is allowed. The delay of 1012 days in filing the application is condoned subject to payment of cost of. ನಿಮಗೆ ಕೇಳಿದ್ರೆ ಭಾರಿ ಕಷ್ಟ ₹1 ಅಂತೀರಾ ನೀವು.
No, what has happened on
What
31
happened,
one,
but,
matter was posted on a particular day, on that day I.
₹1,000 payable to the advocates clerks fund
Clerks
association. Adin hesaru nodkolli. The abatement in respect of petition number 1 is set aside and the person named therein are brought on record as petition number 1A to 1D. Counsel for the petitioner to carry out necessary amendment and file amended petition. Mr. VP Kulkarni. None appears for respond number 5 and 6. If none were to appear for respond number 5 and 6 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner and learned AGA. Relist on 30th January.
40, SM Kalvat.
Application is filed, LS application is filed to bring the LS of the one of the petitioner, my lord. Petition number 1 is died, my lord. And apply.
Put up ಆಗಿಲ್ಲ ಇದು. ಆಗಿದೆ, ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
On 17/12/2024, my lord.
Go for dismissal.
On 10/12/2024, application is filed.
Yeah. 1 to 3 of 24 for dismissal and for the.
On 10/12/2024,
Registry has put up a note that IA 1 of 24 to IA 3 of 24 are for dismissal, which is contrary to the records. IA 1 of 24 has been filed for condemnation of delay. IA 2 of 24 has been filed for setting aside abatement, and IA 3 has been filed to bring the legal representative of deceased petition number 1 on record. The additional registrar judicial is directed to instruct the concerned to make proper entries of the noting in the cause list. Accepting the reasons stated in IA 1 of 24, the delay of 2573 days.
In fact, my lord, what happened previously on the Prakash Jawadi is appearing for a petitioner. So, my lord, after his death, my court notice issued and 17/9/2024, I filed wakalat. And 10/22.
573 days is condoned. Since the counsel who had earlier appeared for the petitioner had expired, and it's only after the court notice was issued that the petitioners came on, have filed the said application. The abatement in respect of petition number 1 is set aside by allowing IA2 of 24 and by allowing IA3 of 24. The persons named therein are brought on record as petition number 1A to 1C. Counsel for the petition to carry out necessary amendment and file amended cause title. Ms. Bentur,
PR Bentur,
none appears for respondent number 3 today. If none were to appear for respondent number 3 on the next date of hearing, the matter would be taken up for consideration on the basis of the submission made by counsel for the petitioner and respondent number 3, relist on 30th January. It is made clear that no further adjournment would be granted. If arguments are not advanced by the petitioner, the petition will be liable to be dismissed for non-prosecution.
Please.
41 BB Somapur, AS Patil.
Who is respondent number 4?
Panchayat Development Officer, my lord. An impleading application was filed in the year 2022. IA1 of 2022 was filed to implead.
To implead R4.
PDO.
PDO ಯಾರು standing counsel?
PDO ಯಾರು standing counsel?
ಇರ್ಬೇಕಲ್ಲಪ್ಪ.
ಇಲ್ಲ. Yeah. Lord, that application is also, PDO ಅಂತ. Which Gram Panchayat then I would make submission.
List ಮಾಡಿದ್ವಲ್ಲ ಅದೆಲ್ಲ.
Allah, that is list. There is a list with regarding to who appears for Panchayat. How? I will furnish them. I will furnish copy.
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗಿದೆ.
ಹೌದು.
ಚೆಕ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್. R4 ಗ್ಯಾರ್ ಕೌನ್ಸಿಲ್ on.
42 BS Kamte.
Yes, for respondent 3 to 9.
Petition number 8 has died, my lord. Application is in time, my lord, application to bring the LRs.
During the pendency of the above matter, petition number 8 expired on?
Lord, 16/8/24, my lord.
16?
16/8/24.
Hence, IA 2 and 3 of 24, IA 1, 2 and 3 of 24 have been filed on?
Lord, 20th December, my lord.
20/12/24. There being no delay, IA 1 of 24 filed for condition of delay is dismissed as not pressed. Accepting the abatement to Baralala.
In fact, not in fact.
Consequently, IA 2 of 24 filed for setting aside abatement is also dismissed as not pressed. Accepting the reasons stated in support of IA 3 of 24, being of the considered opinion that the right to sue survives, said application is allowed and the persons named therein are brought on record as petition number 8A to E. Counsel for the petitioner to carry out necessary amendment and file amended cause title. For extension of interim order.
Last time, 17/1/24. But right from 2018, interim order was extended after hearing both the parties. But on 17/1, my lord, 17/1/24.
Interim order was not to precipitate the matter.
Not to precipitate the matter.
Whatever the interim order is.
Yes, it was lapsed 1 year back. In fact,
17/1 adjourn ಆಗೋಗಿ ಇವತ್ತು ಬರ್ತಾ ಇದೆ.
Second one, my lord, IA 2 of 25 for TI. This is freshly
stated. Accepting the reasons stated in support of IA 1 of 25, the interim order earlier granted is extended till next date of hearing.
In the nature of not to precipitate.
Will also fix the date, my lord.
For the interim order.
Yes, please.
IA 2,
My lord, now they have filed for TI.
IA 2 of 25 will be considered along with the main.
Yes.
Both the counsels are directed to get ready and address their arguments on the next date of hearing. Relist on?
Oh, my lord, in fact, I have filed the entire IA for IA for interim,
28 or
filed
29.
objection, but once again, I formally I'll file it. Allah, already I filed objections to the IA for IA. It was the for.
We have relist on final hearing yavatto?
My lord, on
It will be heard along with the, my lord.
29 or 30th.
Lordship on 30th.
Yes.
Please.
It is made clear that no further adjournment would be granted.
One request, my lord, tribunal records may be direct from
In the
the.
meanwhile, records to be secured by learned AG. and
Yes.
made available for inspection to both the petitioner and the counsel for respondent number 3 to 5.
Yes.
Please.
43, Shant Matpati.
My lords, petition dismissed for non-compliance of office objection, my lord.
Comply ಮಾಡಿದೀರಾ?
My lords, I did not get the file, my lords. My lords, any date may be fixed, my lords. In the meantime, I will comply the office objection, my lord.
The counsel for the petitioner has filed IA 1 of 24, seeking for recalling the order dated 4 September 24, dismissing the above petition for non-compliance with the office objection. Pending consideration of the said application, counsel for the petitioner is permitted to comply with the pending office objections.
Please.
Relist on 3rd February.
Please, my lord. My lords, non-compliance and non-appearance, my lords. Both.
Appearance ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವತ್ತು ಹೋಗಿ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ.
44, Sudhadi.
Please, petitioner, my lords.
Yes.
Petitioner is a licensee in form CL2. My lord, he makes an application on 12th of November 2024 for shifting the premises. Within 3 days thereafter.
Just on Mr. Bhatt.
My lords, one respect to submission, or the copy of the writ petition was served on me only yesterday, my lord.
Yesterday.
And respondent is stationed at Bangalore, my lord. Dispatched this morning the copy of the writ petition. 10 days time may kindly be granted to seek instructions.
Mr. Angadi, I have tried to supply copy
Consider
to
the
Mr. Angadi.
You are not on CCMS platform? Respond number 1?
KRD still appear, my lord. Karnataka Road Development Corporation.
Court case management system ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ದೀರಾ?
That
Kannur ಅವರು
I'll have it added.
I'll verify from Mr. Angadi. He said he is only appearing for land acquisition officer.
ಯಾರು?
Mr. Angadi, I spoke to him. There's a direction to.
Mr. Angadi is appearing for first respondent. His name is
Yes,
there.
he informed me that he is for Leo. That's why I was not. I have no difficulty any date fixed on. 13th maybe, my lord. I can physically come.
But we are ticketing brother Garbadi. CV Angadi, Leonard Counsel appearing for respond number 1. Submit that he was served with a copy of the petition yesterday and he seeks for 2 days time. To
Well,
obtain
10 days time, Lord. Not it's from Bangalore. I had to seek instructions.
interim order ಏನು ಬೇಕು? Consider the application ಅಷ್ಟೇ ಅಲ್ವಾ?
Interim order that road should be closed as it is original state.
1 week nothing will happen, Mr. Bhatt.
Yes, that's fine.
Is granted a week's time to obtain instruction, make his submission. On inquiry as to whether the Karnataka Road Development Corporation Limited is part of the court case management system, he submits that he does not receive any instructions from the court case management system.
Yes.
The court case management system has been established for the purpose of easy communication as regards the litigations relating to the government and government entities. I have the considered opinion that it is not only the government offices and government departments, but all companies, corporation, boards and the like, which would also have to be part of the CCMS. In that view of the matter, the Chief Secretary, Government of Karnataka, is directed to verify the same, and if the aforesaid boards, corporation are not part of the CCMS, to direct them, to enable them to be onboarded to the CCMS along with the respective councils appearing for such boards, corporations, etc. Learned AGA is directed to bring the above to notice of the Chief Secretary to enable her to do the needful. Relist on 21st January.
I will come physically.
To enable the counsel for respond number 1 to make his submissions. In the meanwhile, affidavit of the Chief Secretary to be filed by that date.
Please.
Much.
45.
45, my lord.
Only what?
I appear for the petition, my lord. Yesterday, the impleading application copy is served on me. I request, my lord, on 21st.
Lord,
Yesterday it is served.
Who is the impleading applicant?
The present respondent.
Lord, I am also the councillor,
Huh?
councillor of the Lord Municipal Council.
You are the sitting councillor.
Yes.
Member, my lord, is member whether the matter pertains to rotation. They have filed yesterday, my lord. Certain instructions are
Already,
required.
my lord, notification.
Yesterday it is served on.
In fact,
The
my lord,
interim order.
Yes,
interim order.
interim order is there.
Election, not
21st,
to
your
conduct
lordship,
the
may
election.
I'll
Allow
file
the
objection.
application.
Please,
We'll allow the application and take up for hearing.
please.
IA 1 of 25 has been filed by a member of the
Annigiri Town Municipal Council.
Annigiri Town Municipal Council,
Yes,
contending that the rights of the impleading applicant would also be affected by any orders passed by this court. In that view of the matter, IA 1 of 25 is allowed. The person named therein is brought on record as respondent number 7. Counsel for the petitioner to carry out necessary amendment to the cause title and file the amended cause title.
please.
R5 arrow.
R5 is the Town Municipal Council. President.
Why have we not paid the process fee?
Process piece, my lord, it is served to the respondent number 1 to 6.
Lord, one Mrutyunjaya Pujari, Lord,
His name is
Arrow.
Mrutyunjaya Pujari.
Wakalat.
So ನಾನು ಸ್ಪೆಲ್ಲಿಂಗ್ ಗೊತ್ತಿರಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ ನೀವೇ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. So and so is directed to accept notice. He has filed wakalat.
He has filed the wakalat.
It is submitted that so and so has filed wakalatnama for respondent number 5. Registry to verify and print his name as that appearing for respondent number 5. In that view of the matter, there would be no requirement for furnishing process fee, copies or acknowledgement for having served the hand summons. Of his objections.
Please, my lord, further objections, my lord, I'll comply with during the
One
course. During the
submission.
course.
As on today, the present writ petition may not survive for consideration on the simple fact of the notification on which the reservation was fixed. One of the candidate, since my lord, who was belonged to scheduled caste, approached this honorable court challenging that notification that the reservation is fixed for ST women. Since there was no candidate for that, the other SC candidate approached this honorable court, and this honorable court caused the entire notification itself. May I pass on the order? That notification itself has gone.
Petitioner is a ST woman.
Now the present petitioner.
No, she
No.
was not. No, in fact, Lord, where I.
I'm not
prepared
petitioner, SC
I
woman.
had prepared the lit petition stating that Lord, there is not, the post was reserved for ST women.
Yes.
No ST woman candidate, Lord, in the Lord Annigiri TMC. Lord, I belong to ST Lord category. Lord, that was Lord challenge notification was quashed. And Lord, re-notification was issued on the basis of the order passed by this honorable court.
Based on that, my lord, subsequently elections have been, calendar of events have been issued, and yesterday the date was fixed to hold the election. In view of the interim order granted by this honorable court, my lord, yesterday we could not proceed with the election. This fact has been suppressed by the
Petitioner is belonging to SC woman, my lord.
Just a moment. Now the election is for the president.
Yes. It is for the post of president. Yes.
You are a elected councillor.
Yes, I am also elected member, my lord. The respondent is also elected member.
No, he belongs to Lord SC category.
My lord, I belong to SC woman. The roster is for ST woman, my lord. He also does not belong to that roster. I also do not belong to that roster. Now the matter is pending before the Supreme Court, my lord. The challenging rotation.
You belong to what category? SC male.
Yes. ST male.
ST male.
I belong to SC woman. The roster cannot be the
firstly whether ST has to be given preference to SC or SC woman has to be given preference to
yes.
Needless to say, it will be always the ST will be given the preference.
Yes, but the roster, my lord, under which the present roster 28/5/2024, the roster under which it is passed, that matter is still pending before the Supreme Court. Supreme Court's direction prakarane the notification was issued, and in that, my lord, it was reserved to ST women. Now the matter is still pending before the Supreme Court. Now, without bringing it to the notice of the apex court, my lord, they have changed the roster, and now they are holding the election for the present. Now that is why.
Of the order passed by this court.
Yes.
Further, the order passed by coordinate went to this court on 26th
Not
September.
that judgment. Not that judgment.
ಅದಾದ್ಮೇಲೆ notification issue ಅಂತ ಹೇಳಿರೋದು.
We are not part. ಹೌದು. ಅಲ್ಲ, it is.
ಇದಾದ್ಮೇಲೆನೇ ಆಗಿರೋದು ಈಗ.
ಅಲ್ಲ, we are not.
Same and issue fresh election notification. And further, the orders of this court.
5/8 notification was challenged, Lord, in that writ petition.
ಇಲ್ಲ,
Subsequently, my lord, in
You
person.
That
have to
notification
challenge-
itself.
If you are aggrieved by this order, you should challenge.
No, I am
it.
not party, my lord. This is not, this is prior to the present writ petition, prior to the Supreme Court's, my lord, direction.
No.
I will look into this, my lord. May I request,
Santosh,
please?
the notification has been issued in furtherance of the orders passed by this court.
No. That is incorrect. The notification is issued in furtherance of the directions of Supreme Court, not by this court.
And also this court.
Yes.
Please see para 4.
Yes. Redo, my lord. This
Because
matter
there
is,
is no
this SLP
candidate
is
of-
still pending.
There is no dispute that there is no candidate of ST woman.
Yes. ST woman candidate illa.
ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ನೀವಿಬ್ರು ST woman ಅಲ್ಲ.
ಅಲ್ಲ. Yes.
Sir, SC woman is ST male.
ST male. I'll look into this judgment. One short.
Preference has been given to the
Yes.
ST.
But my lord, I've referred to several judgments.
So this one will come whenever next time.
That roster itself, my lord, is under challenge Supreme Court. And secondly, this honorable court and the Supreme Court in Saraswati's judgment.
We'll do one thing. We'll dismiss your petition, giving liberty to you to approach the Supreme Court.
The judgment, my lord.
In the way of election of the president.
No, I will not coming in the election, way of the election. My lord, I will look into this.
If you say that it's pending before the Supreme Court, go before the Supreme Court.
Yes, my lord, this
But
judgment.
yes, we'll dismiss your petition now.
This judgment is now produced to me, my lord. I will request for 2 days. I will look into and I'll look into and submit, my lord. Because Supreme Court pending, what is the status?
Learned counsel for the petitioner submit that the issue in question is pending before the Honorable Apex Court in SLP Civil number 7090 of 2021. If that be so, the above petition is not maintainable and it was for the petitioner to approach the Honorable Supreme Court. Faced with the above situation, learned counsel for the petitioner seeks for and is granted 2 days' time to obtain instruction, make his submission. Relist on 9th January.
Please. On merits, my lord, on merits I'll submit because
merits ಏನಿಲ್ಲ Supreme Court ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು ಅಷ್ಟೇ.
Supreme Court, my lord, in the Supreme Court notification, I'll submit, my lord, because
whatever orders you want, you can get there.
Yes.
We are still open.
Yes,
Kindly the matter to be taken in the next week, sir.
Next week.
Previous
Your
matter,
Lordship.
interim order.
45 interim order earlier granted is extended till next week. At the request of counsel for the petitioner, accepting the reasons stated in support of IA 1 of 24, the production certified copy of Annexure F is dispensed with. Learned AGA accepts notice for respond number 1 to 5, 7, 8 and 9. MSIL ಯಾರು?
MSIL, my lord.
CBN.
CB ಅಂಗಡಿ.
Mr. Angadi.
CBN.
MSIL, ಹಳ್ಳಿಕೆರೆ. ಮುರ್ತುಂಜಯ ಹಳ್ಳಿಕೆರೆ.
Mrityunjay Hallikeri is directed to accept notice for respond number 6. Notice to respond number 10 is deferred for now. At the request of counsel for the petitioner, released on 21st January.
Obliged.
47. Secretary Nagmuri.
Seeking for a mandamus to consider my objections, my lords.
Objections?
Yes, my lords. Not to mutate the name of my neighboring landowner, my lords. What has happened is, respond number 1 herein had filed a writ petition before this honorable court, praying to mutate his name in the records of his property. That writ petition was allowed, my lords. The survey number which is mentioned in that writ petition order is with respect to my land. Lords, I am not a party to that writ petition order, in that writ proceedings, my lords. Lords,
then you'll have to serve respond number 1.
Yes.
Lord AGA accepts notice for respond number 2 to 4. Issue emergent notice to respond number 1, returnable by 10th February. Counsel for the petitioner is also permitted to take out hand summons to respond number 1.
Lords, what has happened is, on the strength of that order, my lords, they are trying to mutate.
We can't pass any order without them being here. You are only asking for a mandamus.
If they mutate, they have to challenge that. If they mutate, they have to challenge that.
Lords,
but our objection
status quo order at least may be granted.
But your lordship, even if he is agreed by the mutation, you have to challenge that.
If he is all, why double this one?
And my lords,
can always consider it.
The authorities are.
I am not disputing that aspect. But he was not the party, Your Lordship, in the earlier writ petition. And this Honorable Tribunal, Your Lordship, Annex D.
Or we'll dispose it of with a learned AG accepts notice for respond number 2 to 4. Notice to respond number 1 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following relief. The only grievance of the petitioner is that the objection stroke representation submitted by the petitioner in respect of the application filed by respond number 1 seeking for entry of her name in the revenue records in respect of RS number 280 stroke 1 plus 2 plus 3 stroke B, old RS number 280 stroke 1 plus 2C, situated Unnargi village, Nipani Taluk, Belgavi district is not being considered. In my considered opinion, the said above writ petition is premature inasmuch as whenever any objections are filed, it would be the obligation of any officer of the state to consider the objections in respect of any application filed by any other person. If the concerned officer were not to consider the representation, the same would amount to abdication of duties. And as such, the presumption on part of the petitioner that respond number 2 to 4 will not consider the objections filed by the petitioner cannot be sustained on the face of the present petition. In the event of the respond number 2 to 4 not considering the representation objections, the petitioner would always have a remedy of an appeal. And of course, action could also be taken against respond number 2 to 4 for not considering the objections filed. With the above observation, the petition stands disposed. It is made clear that this court has not adverted to or made any observation on the merits of the matter.
48, T.N. Osmane.
Second respondent has passed order, my lord, declaring the petitioner's land as unrecorded habitat, my lord, without issuing notice to, my lord, the petitioners and interested persons.
Could you repeat that?
No, under 38A, my lord, on Land Reforms Act, my lord, the DC Koppal has passed order declaring the petitioner's land, private lands, as unrecorded habitat in order to declare that as Kandaya Grama.
What is the document in your possession to show that you are the owner of this land?
My lord, my grandfather is ancestral property, my lord. My grandfather's name still continues, my lord. And we filed a suit for partition, which is pending, my lord. Wherein, my lord, in other interested persons also filed similar petitions, my lord, connected petitions, wherein, my lord, this honorable court granted the interim order of stay, my lord. Wherein, my lord, there are Harish Chandrappa has three sons, my lord. Wherein I am the daughter of second son Chintappa, my lord. Wherein this is the ancestral property, my lord. Wherein, my lord, without issuing notice to the interested persons, wherein the persons having a right over the property, my lord, only based on the report submitted by the revenue inspector, and wherein, my lord, the villagers have submitted that they have no objection to declare this area as a Gaunthana, my lord. Based on that report, my lord, DC Koppal has passed order as unrecorded habitat and in order to declare as a revenue village.
Before 3D notification being issued, no objections are invited.
But by presuming that, Your Lordship, it is not coming.
There is no reference, my lord, even
The report of the Tahsildar and Thirtare, Assistant Commissioner, proposal of the Assistant Commissioner.
As per the annexure, Your Lordship, it is not forthcoming whether the objection. As per the impugned order, it is not forthcoming.
Not forthcoming.
Even there is no
And
reference.
AGA accepts notice for respond number 1 to 4. Gram Panchayat Kushtigi Yaro. PDO Kushtigi. ನೀವು ತಿಳ್ಕೊಂಡು ಬರಬೇಕು ವೆಬ್ಸೈಟ್ ಅಲ್ಲೆಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿದೆ ಇವಾಗ ಯುವರ್ ಆಬ್ಲಿಗೇಷನ್ as a counsel for the petitioner ನಾವು ಹುಡುಕದಲ್ಲ she so and so is directed to accept notice for respond number 5 learned AGA is directed to secure instruction make a submission as to whether before issuance of the notification impugned notification under section 38 capital A at annexure A whether any objections were called for by the Deputy Commissioner. Until then, the respondents are restrained from acting in pursuance of Annexure A, released on 21st January.
Connect ಮಾಡ್ಸೋಡಲ್ಲ.
Accepting the reasons stated in support of IA 1 of 24, the production of certified copy of Annexure A is dismissed.
There is connected matters, my lord. There are earlier, my lord.
Connect with
Let petition 103.
number birth ಕೊಡಿ.
Please.
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಅಲ್ಲೊಂದು ಹಗ್ಗ ಕಟ್ಬಿಟ್ಟು ಈ ಪೇಪರ್ಗಳ ಎರಡು ಕಡೆ ಅವ್ರು ಬರ್ಕೊಡಕ್ಕಿದೆಯಲ್ಲ, ಅವಾಗ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ.
59, Vinay Kausalgi.
Yes, Mr. Kochali.
Yes, the order of the Deputy Commissioner is under challenge, my lords. The history is that the petitioner herein had filed a suit for partition in separate possession. That was decreed and confirmed by this honorable court. I filed FDP, my lords. In FDP portion, surveyor submitted report and final decree was drawn, my lords. Thereafter, in execution petition, portion was demarcated and possession was given to me. As per FDP, final decree and execution petition order, name of the petitioner was mutated, my lords. Thereafter, there was delay after of 3 years. He files the respondent number 1 files an appeal before this honorable court, challenging the final decree and execution petition order, my lords. In that appeal, stay was granted. Based on that, the deputy commissioner orders for change of mutation, my lords.
You have an appeal remedy, alva?
Appeal assistant commissioner he filed appeal. That is a respond number 1. In appeal was dismissed. Against that, he filed revision before the deputy commissioner.
Revision before the deputy commissioner.
Deputy commissioner. In deputy commissioner, as there was a interim order granted by this honorable court in RFA, the mutation was ordered to be changed. Order is at page number 21.
AGA accepts notice for number 226. Issue emergent notice to respond number 1 returnable by 13th February.
I sought for stay of
operation and execution of the order date 12/11/24 bearing number so and so passed by respond number 2 in revision petition number
RBRTA 1 of 2024-25.
Order dated 12/11/24 passed by respond number 2 in revision RBRTA so and so. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 8 January, failing which the interim order will stand automatically vacated.
Please.
50, Girish Dharwad.
For the petitioner. Petitioner is calling in question the interim order passed by the election tribunal, rejecting an application filed by the petitioner, who was the original respondent number 2 before the tribunal, seeking his transposition as a petitioner in the election petition.
Who are you?
I am also one of the candidates, 3 candidates who contested the election.
Yes.
I am the original respondent number 2 in the election petition, my lords.
You are unsuccessful candidate.
I am the unsuccessful candidate. Respondent number 1 is the successful candidate. Another unsuccessful candidate who was the petitioner filed the election petition.
Yes.
In the first instance, my lord, the election petition was dismissed. That was called in question in an appeal before this honorable court. This honorable court allowed the appeal on the ground that the tribunal did not frame proper issues and remanded the matter, reserving liberty to the parties to adduce, my lord, additional evidence on the additional issue framed by this honorable court in that appeal itself. Pursuant to that, my lord, there is an apparent collusion between the petitioner.
Can't help it.
Please.
Can't help it.
He files a memo.
You have filed a EP at that time.
The only reason is
you are aggrieved. You can't now transpose.
Now, my lord, he files a memo before the election tribunal saying that, my lord, he is not interested. But
withdraw.
My withdrawal cannot be, my lord. Say, election petition is not a, my lord, list between, my lord, 2 candidates. My lord, all the voters of the constituency are affected by the result. Now, my contention is
affected. You have to file the proceedings in terms of the applicable law within the time.
No, one unsuccessful candidate has now, my lord, filed election petition. I was made as a party. He was contesting. He contests still, my lord.
You are not even required to be made a party.
True.
You are only required to be made a party only if one other relief is sought for by the petitioner to be declared to be elected.
He sought declaration, my lord, that his election is null and void. And now, my lord, he cannot withdraw this election petition. That is my basic contention.
Who cannot seek for transposition, Mr. Dharwad?
Now, the application is rejected on two grounds. One is that, my lord, this honorable court in the appeal said that no party will lead additional evidence. No, will not amend the pleadings.
That is immaterial. You cannot seek for transposition in election.
I am also the candidate who contested the election.
Right,
In my humble submission, my lord, I have that at least limited right to see that the election petition is taken to a logical end.
No, you don't have any right. Unless you do it as per the statute.
I was a party. That my lord, in my humble submission, my
First
lord,
instant, he has not contested the petition at all.
our caveat ಹಾಕಿದ್ದಾರೆ.
Shri KL Patil and Shri SS Beturmat who have filed caveat for respond number 2, accept notice for respond number 2. And AGA accepts notice for respond number 4 and 5, 3, 4 and 5. Notice to respond number 1 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The respond number 1 had filed an election petition in EP number 1 of 2022 against respond number 2 to 5 and the petitioner under section 21 of the Karnataka Municipalities Act 1964, seeking the relief of declaration to the effect that election of respond number 2 to Amingarh Patan Panchayat from ward number 16 is void and illegal, and for a declaration that he is the successful candidate. The submission of the alleging that there is collusion between respond number 1 and respond number 2, the petitioner had filed an application for being transposed as a petitioner in the aforesaid election petition, which came to be dismissed wide order dated 16/12/2024 passed by a senior civil judge and JMFC Unugun. It is challenging the same. The petitioner is before this court. Shri Girish A. Dharwad, learned counsel for the petitioner, would submit that there being apparent collusion between the petitioner, between respond number 1 and respond number 2, that is the election petitioner and the successful candidate. The petitioner has a vested right to ensure that the challenge to the election of the successful candidate reaches its logical conclusion. There being a collusion between the election petitioner and the successful candidate, the petitioner, who is one other candidate, wanted to transpose himself as election petitioner to prosecute the matter, which could not have been negated by the trial court in the manner so done. And as such, he submits that the order passed by the impugned order passed is required to be set aside, and the application filed in IA number 15 under order 1 rule 10 of the Code of Civil Procedure is required to be allowed. Idu Kodi, Karnataka Municipalities Act. Shri SS Beturmat, learned counsel for respond number 2, would submit that a election petition is a statutory remedy, and any claim, if were to be made, would have to be made in terms of the applicable statute. The petitioner not having challenged the election of respond number 2, the same cannot be sought to be challenged by seeking for transposition in the pending election petition, and as such he submits that the court has properly dismissed the said election petition.
Application.
The application filed in the election petition. Shri Kalsurmat learned AGA submits that.
Contentions of the.
Yarik supportment.
I will support the order passed by the court below.
So he supports the order passed by impugned order and submit that no fault can be found therewith. Having heard the learned counsels for the petitioner and the respondent, The short but important question that would arise for consideration is whether a respondent to an election petition can seek for transposition as a petitioner in an election petition on the ground that the election petitioner and the successful candidate have colluded with each other. Section 21 of the Karnataka Municipalities Act 1964 is reproduced hereunder for easy reference. A perusal of subsection 1 of section 21 would make it clear that no election of a councillor shall be called in question except by an election petition presented to the election tribunal within 15 days from the date of declaration of the result of the election. Subsection 2 of section 21 provides for the petition to be presented on any of the grounds specified in section 23 by any candidate at such election or by any voter of the ward concerned. The petitioner would also be required to join as respondents to his petition all the candidates at the election in terms of subsection 3 of section 21. Section 23 of the Karnataka Municipalities Act 1964 is reproduced hereunder for easy reference. An election petition could be filed only in terms of the grounds mentioned under subsection 1 of section 23. And orders passed thereon. Reading of section 21 and section 23 would indicate that any petition challenging an election would have to be couldn't be filed by a candidate or a voter within 15 days from the date of declaration of the result of the election. In the present case, such a petition had been filed by respondent number 1 in election petition number 1 of 2022. And it is only on when did you file the application?
Yes, I filed my application. 47, page 47. Minutes.
It is only on 22/2/2024 that the petitioner filed an application IA number 15 and order 1 rule 10 of the Code of Procedure to transpose him as a petitioner. That is, from the time of filing of the petition, election petition on 13/1/2022 till 22/2/2024, the petitioner had no grievance as regards the election of respondent number 2. And it is only alleging that there is collusion between the election petitioner and the successful candidate that the aforesaid application was filed. A challenge to an election is a serious matter, and any such challenge can be made only in terms of the applicable statute and not otherwise. Section 21 clearly mandating that a challenge has to be made within 15 days. Any person aggrieved by the election is required to file the said election petition within 15 days of the declaration of election and not otherwise. There is no vested right created in the respondents to election petition as regards the reliefs which have been sought for in an election petition. If at all the petitioner was aggrieved by the election of the successful candidate, he could have always filed a separate election petition challenging said election, which could have been tried along with EP 1 of 2022 or independently. That not having been done, after a period of 2 years after the election, the question of a respondent in an election petition seeking for transposition as a petitioner to continue the petition would not arise, there being no vested right in favor of such a respondent, the same being barred under section 21 of the Karnataka Municipalities Act 1964. The transposition of a party in a proceedings can only arise if there is such vested right or interest for such transposition and where the right could be decided by the court. In the present case, the petitioner not having filed an election petition cannot seek for transposition after more than 2 years of the filing of the election petition by respondent number 1. Hence, I answer the point raised by holding that a respondent in election petition cannot seek for transposition as a petitioner on the ground of collusion between the petitioner and the successful candidate or any other ground. It was, if at all a candidate in election is aggrieved, such candidate would be required to file necessary election petition in terms of the applicable law within the applicable time frame fixed thereto. Para. In view of my answer to the aforesaid question, aforesaid point formulated, the petitioner in the present case being a respondent and not having independently challenged the election of respondent number 2 could not have filed an application for transposition under Order 1, Rule 10 of the Code of Civil Procedure. I do not find any infirmity in the order passed by the trial court. The petition, not making out any grounds, stands dismissed. Please.
51, Venkatesh Kharvi.
Kindly pass out members.
Pass over.
The group matter 52, V. Vidya. A. Raghavendra.
Madam Judge, next week, not if it could be taken.
Please, we'll do it next week.
We'll do it.
At the request of counsel for the petitioner, relist on 23rd January, it is made clear that no further adjournment would be granted, considering that the matter is of the year 2007. If arguments are not advanced by the petitioner, petition would stand dismissed for non-prosecution. If arguments are not advanced by the counsel for respondent number 5, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner and the learned GA.
In the meantime, lots of records and lots maybe.
In the meanwhile, records to be secured by learned AG and made available for inspection to the counsel for the petitioner and respondent number 5.
Yes.
Yes.
53, H.M. Dharigon.
Records banta?
Petitioner challenge the annexure A because not received.
Learned AGA submit that the records have not been received. He seeks for and is granted 10 days time to secure the records. If the records are not secured by next date of hearing, yaar kodbeko?
Deputy Commissioner.
Deputy Commissioner.
Respondent number 1.
First respondent.
Respondent number 1 shall be personally present before this court. Relist on 30th January.
55, S.C. Hiremat.
Idu banta?
Correspondent 4 to 9.
The records 55.
55, I think received your lordship next week. Your lordship.
Received, huh?
It's right. I think
ಆಗಿರ್ಬೇಕಾ ಆಗಿದೆಯಾ?
ಯಾಕಂದ್ರೆ ಅವ್ರು ಎಮ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಮ್ ಅಂತ ಇದೆ ಇಮ್ ಟೇಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ಅದರಲ್ಲಿ ನೋ ಅಂತ ಕಳ್ಸಿದ್ರು
ಸೊ ಇದು ಬಂದಿದೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅದಕ್ಕೆ ಆಮೇಲೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಕಷ್ಟ ನಿಮ್ಗೆ ರೆಕಾರ್ಡ್ಸ್ ನಿಮ್ಮನ್ನ ನಡಿಬೇಕಾಗತ್ತೆ ಕ್ಲಿಯರ್ ಆಗಿ ಚೆಕ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ ಬಂದಿದ್ರೆ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕೊಡಿ ಇಲ್ಲಾದ್ರೆ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು
56, S.K. Kaikmat.
2 days accommodation. 2 days accommodation.
What is memo of 4 to 22?
Senior.
Memo ನೋಡಿ ಅದು. The memo dated 4/2/2022 filed by the counsel for the petitioner is taken on record. Bari state, huh?
Statement.
Bari state. Pass over.
Tomorrow.
Tomorrow. At the request of counsel for the petitioner, released tomorrow.
8/1. 7 Lakshman T. Matagani for the petitioner.
Yes.
Madam, here, madam, the petitioner is the purchaser of the property.
Only government, ಬೇರೆ ಎಲ್ಲ served. Ready?
Yes.
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 It is a case of following. It is a case of following, Your Lordship.
Yes, because madam, here.
Certificate code
Yes.
Just Your Lordship.
Because the 1970, madam, the plan was, layout plan was approved. Subsequently, madam, as per impugned order, it was madam, through overnight. It has been madam, without cancelling that, madam. Again, madam, the survey has been conducted and it has been cancelled. I already constructed. I am in possession of the property. So, Lordship kindly take madam, the annexer B. Annexer D, madam, page number 40.
When was your plan approved?
Madam, it was approved in the year 1970. I have also produced along with madam, memo.
1970.
1970. 1970.
And it was converted.
Yes, it was converted, madam. It was converted, madam, subsequently. Your Lordship kindly see, madam, annexer E, that without looking into that, madam, conversion and also, madam, annexer D is
How
the
did
conversion.
the plan get approved without conversion?
Conversion agide. Conversion
Subsequently, antira?
Alla, subsequently, it was, madam, mutation in trace came to be, madam, certified.
When was the conversion order?
Conversion, madam, order was in the year 1970, madam, prior 19.
ಎಲ್ಲಿದೆ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಆರ್ಡರ್ ಇಲ್ಲ, ಕನ್ವರ್ಷನ್ ಆಗಿದೆ ಅಂತ ಅವಾಗಿದ್ ಮಾಡಿ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಟೇಕ್ ಮಾಡಿ
ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ತೋರಿಸಿ.
ಆರ್ಡರ್ ಇಲ್ಲ, ಆರ್ಡರ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಇಟ್ ವಾಸ್ ಗವರ್ನಮೆಂಟ್ ವಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಸೆಕ್ಯೂರ್ ದಟ್.
ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್, ಅವ್ರು ಏನಕ್ಕೆ?
ಅಲ್ಲ, ನಾವು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರು, ಹಿಂಗಾಗಿ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಇಲ್ಲ.
ಕಾಪಿ ಇಲ್ವಾ ನಿಮ್ಮ ಫೈಲ್ ಅಲ್ಲಿ? ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ವಾ ಕನ್ವರ್ಷನ್?
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಟೇಕ್ ಮಾಡಿ ಸೇಲ್ ಡೀಡ್ ಮ್ಯುಟೇಷನ್ ಇದು ಆಗಿದ್ದು annexer D ದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 40 ದಲ್ಲಿ ಬಿನ್ ಸೇತ್ಕಿ ಪ್ಲಾಟ್ ಖರೀದಿ ಅಂತನಾ ಬರುತ್ತೆ. ಬಿನ್ ಸೇತ್ಕಿ
40.
ಎಸ್, ಪೇಜ್ 40 ಹಕ್ಕು ಪತ್ರ. ಎಸ್, ಬಿನ್ ಸೇತ್ಕಿ ಪ್ಲಾಟ್ ಖರೀದಿ ಅಂತ ಹೇಳಿ ತಾರೀಖು 11/78 ಇಸ್ವಿ ಬಾಜುಗೆ ಬರೆದ ಸರ್ವೆ ನಂಬರ್ದಲ್ಲಿ ಪ್ಲಾಟ್ ನಂಬರ್ 7 ಇದರ ಪಟ್ಟ ಸೋನ್ಸೋ ದಿವಸ ರೂಪಾಯಿ 6,000 ರಾಜಶೇಖರಪ್ಪ ಹಳ್ಳಿಕೆರೆ ಇವರು
78 ಆಯ್ತು. 73 ಬಿಫೋರ್ 73 ವಿ ಸಿ.
ಬಿಫೋರ್ 70 ಅಲ್ಲ, ಖರೀದಿ ಮಾಡಿದ್ದಾರೆ. ಬಿನ್ ಸೇತ್ಕಿ ಖರೀದಿ ಮಾಡಿದ್ದಾರೆ.
ಖರೀದಿ ಮಾಡ್ಕೊಳ್ಳಿ.
ಹಾ, ಬಿನ್ ಸೇತ್ಕಿ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಕನ್ವರ್ಟೆಡ್ ಲ್ಯಾಂಡ್.
We need the conversion order and the plan approval.
Approved, plan approved, madam, I have produced along with memo.
Page.
Along with
memo,
separate memo.
Where did it be?
Yes, I have produced that. Only after, madam, conversion layout, this plan layout has been approved.
Memo for approval.
Memo, madam.
8/1/2013.
Yes.
8/1/2013.
Subsequently, madam, I have heard, when the matter was. 7th March 9, 2022 ದಲ್ಲಿ I have produced, madam.
Dates are all different in this from what you're saying. This is saying 23/6/69. And ಇನ್ನೊಂದು ಡೇಟ್ 5/12/2014 ಇದೆ HDMC ಇದು.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕೊಟ್ಟು ಅವರು ತಯಾರು ಮಾಡಿದ ನಂತರ ತಯಾರು ಮಾಡಿ ಇಟ್ಟಿದ್ದು.
ಅಪ್ರೂವಲ್ ಯಾವಾಗ ಆಗಿದ್ದು?
ಅಪ್ರೂವಲ್ ಅವರು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬಿಫೋರ್ ದಟ್ ಮ್ಯಾಪ್ ಮರಡ್ ಗಿವನ್ ಎ ಮರಡ್.
HDMC has approved it.
ಹೌದು.
HDMC ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
ಅವ್ನು ಪಾರ್ಟಿ ಮಾಡಿ.
ಇಲ್ವಲ್ಲ HDMC
ಬುಡಾ ಪಾರ್ಟಿ.
ಅವ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಕ್ಕೆ AC
Standing Counsellor Gurudev. The contention of the learned counsel for the petitioner is that there was a layout plan sanction granted by the Dharwad Municipal Corporation.
Urban Development Authority. Urban Development Authority.
HDMC na
Urban Development Urban Development Authority.
Dharwad Planning Authority.
Planning Authority. That is a planning
authority. Prior to the amendment to the Karnataka Land Reforms Act coming into force,
Please.
And that layout had been formed. In that view of the matter, to ascertain the veracity of the statement, I am of the considered opinion that the Dharwad Planning Authority is required to be made a party to the present proceedings, and as such is brought on record as respond number 8. Counsel for the petitioner to carry out necessary amendment and file amended cost title. ಯಾರು ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿಗೆ? ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿನೂ HDMCನೂ ಅವರೇ ಇದೂನು ಅವರೇ.
ನಾನು ಅದೇ ಕಾಯಂ ಆಲ್ಸೋ.
ನೀವು ಆಗಕ್ಕಾಗಲ್ಲ. ಶ್ರೀ ಗುರುದೇವ್
ಇವರು ಶರಣಗೌಡ ಶರಣ್ ಬಸವ ಇದೆ.
ಗುರುದೇವ್ ಬರ್ತಾ ಇದ್ದಾರಾ ಇಲ್ವಾ?
ಸ್ವಲ್ಪ ಹುಷಾರಿಲ್ಲ.
B. Sharan Basava is also there in the panel. B. Sharan Basava is also in the panel.
Shri B. Sharan Basava is directed to accept notice for respond number 8, obtain instruction, make a submission as to whether any plan sanction had been granted in respect of RS number 54/1A of Saptapur, Dharwad by the HDPA, and has also produced a copy thereof. Learned AGA is also directed to ascertain if the land in survey number 54/1A of Saptapur, Dharwad had been converted for agriculture to non-agriculture purposes, and produce a copy of the conversion order. Released on 30th January.
Please.
Counsel for the petitioner to furnish 2 sets of the petition along with annexes on Mr. Sharan Basava.
Please. Permitted to.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದೀವಿ. ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು ಇವೆಲ್ಲ.
58 ಬಾಹುಬಲಿ ಕನಬರ್ಗಿ.
Correspondent number 1, madam. Next week it may give. 1 week time.
Ready, madam?
Yes, sir.
Learned counsel for the petitioner is present and ready to address the arguments. Counsel for respond number 1 seeks for a short accommodation. Released on 24th January.
Please, oblige.
It's made clear that no further adjournment would be granted.
Please.
59 BB Somapur.
Kindly next week, my lords. Kindly next week, my lords.
An issue notice, there's no interim order also.
No.
Could this survive?
To ascertain, my lords. Kindly next
And
week.
counsel for the petitioner seeks for and is granted a week's time to get ready and address arguments. Released on 23rd January. It's made clear that no further adjournment. If arguments are not advanced by the petitioner, dismissal. If arguments are not advanced by respondent, it will be taken up for consideration on the basis of submission by the counsel for the petitioner.
Oblige.
Srinand Pachapure.
Here, not the 5 brothers, my lord, have executed, who are uncles of the, my lord, the original petitioner. They have executed oral gift, my lord, the Hiba.
V.K. Patil, S.V. Deshpande, pass over.
Please.
ಅದು ಯಾಕೆ ಅದು ವಿಡಿಯೋ ಒಂದೇ ಬರ್ತಾ ಇದೆ, ಫುಲ್ ಬರ್ತಾ ಇಲ್ಲ ಸ್ಕ್ರೀನ್? ಯಾಕೆ ಬರಲ್ಲ? ಇಲ್ಲ ಬರ್ಬೇಕದು ಫುಲ್. ಇಲ್ಲಿ ಹಿಂಗ್ ಬಂದಂಗೆ ಅಲ್ಲಿ ಬರ್ಬೇಕು. ಇದೆಲ್ಲ ಬಂತು ಫುಲ್ ಸ್ಕ್ರೀನ್ ಬರ್ಬೇಕು.
Ahmad Ali Rahman.
In this, I am for respond number 2, my lord. He has filed a writ of Mandamus directing the respond number 2 to enter his name in the concerned records. He has, respond number 3 has filed a suit for declaration and injunction. That suit came to be dismissed. The property mentioned in that suit and the property mentioned in this writ petition is entirely different.
2014 ಆದ್ಮೇಲೆ ಇವಾಗ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇದೆ. ಏನ್ ಇಷ್ಟೆಲ್ಲ ಏನಕ್ಕೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲ? ಇದೆಲ್ಲ ಲಿಸ್ಟ್ ಕೊಟ್ಟ ಮೇಲೆ ತೆಗಿತಾ ಇದ್ದೀರಾ. ಇದು ಅಷ್ಟೇ, ಇವೆಲ್ಲ 2014 ಆದ್ಮೇಲೆ ಬರ್ತಾ ಇದೆ. ಎಲ್ಲಿ ಅಹಮದ್ ಅಲಿ ಅವರೆಲ್ಲಿ ಬಂದಿದಾರಾ?
ನೋಡಿಲ್ಲ.
ಪಾಸ್ ಓವರ್ ಇಲ್ಲೇ ಇರ್ತೀರಲ್ಲ?
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
62 Hanuman Reddy Saukar. Hanuman Reddy Saukar.
Pass over.
63 Avinash Bankar.
I request Lords to have it next week. ಅಂದ್ರೆ partition suit was pending and ಅದು ಮುಗಿದೋಗಿದೆ.
2011 ಇಂದ you are sitting on a status quo. Mr. ಅಂಗಡಿ ನೀವ್ ಯಾಕೆ ಮೂವ್ ಮಾಡಿಲ್ಲ?
Since civil suits are pending for consideration, my lord. ಅಲ್ಲ ಅದು it went up to Supreme Court ಎಲ್ಲ ಮುಗಿದಿದೆ. So ಅದು ಏನ್ ಸ್ಟೇಟಸ್ ನೋಡಿ ಮುಗಿದಿದ್ರೆ I will withdraw this petition.
Both the councils seek for and are granted a week's time to obtain instruction and make the submission as regards the outcome of the civil suits.
Please. Yes.
Which were pending before the between the parties.
Please.
Released on 22nd January.
Please.
64 Srinand Pachapure.
Yeah, for respondent number 1.
It's petitioner, my lords, filed an application seeking regularization, my lords, of unauthorized occupation. A spot inspection was my lords conducted, and the statements were recorded by the revenue inspector, and accordingly, my lords, Sagwali chit was issued, my lords.
You're appearing for respondent number 1 and 5.
Yes.
Who is 5? 5 ಯಾರು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
1 ಅಷ್ಟೇ.
ಬರೀ 1 ಇದ್ದಾರೆ. 2, 3, 4 are government officers.
Appear only for 1.
5 ಯಾರು ಇದ್ದಾರೆ?
ಇಲ್ಲ.
ಇಲ್ಲಿ 1 and 5 ಅಂತಿದೆ ನಿಮ್ಮ ಹೆಸರು.
R1, my lords. GA for R2, 3 and 4.
R1. Registry is directed to correct the appearance of Shri K. Raghavendra Rao and V. Vidya as that appearing for respondent number 1. Since there is no respondent number 5 in the array of parties. Yes.
Respondent number 1, my lords, who is no way, my lords, concerned with this property, who has not made any application seeking regularization, my lords. He challenged the said issuance of Sagwali chit before the assistant commissioner, my lords. That appeal came to be dismissed, against which, my lords, an appeal was preferred to the deputy commissioner. There, my lords, the deputy commissioner, my lords, without assigning any proper reasons, has, my lords, directed the assistant commissioner to take steps under section 108K for cancellation of the grant, my lords. Impugned order is at annexure A, my lords.
Assistant commissioner rejected, deputy commissioner allowed.
Allowed.
He has remanded the matter.
Remanding the
He has
matter,
remanded it, my lords, for fresh inquiry.
Only inquiry.
Yes. Page 12, my lords, operative portion of the order. ಮೇಲೆ ವಿವರಿಸಿದ ಅಂಶಗಳು ಮತ್ತು ಕಾರಣಗಳಿಗಾಗಿ ಸಹಾಯಕ ಆಯುಕ್ತರು ಮಾಡಿದ್ದ ಆದೇಶ ನಂಬರ್ so and so dated 21/8/2009 ಅನ್ನು ರದ್ದುಗೊಳಿಸಲಾಗಿದೆ. ಸಹಾಯಕ ಆಯುಕ್ತರು ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 108ಕ್ಕೆ ಅಡಿಯಲ್ಲಿ ಸಕ್ರಮ ಸಮಿತಿಯ ಆದೇಶವನ್ನು.
What is the reason for passing this? What is your objection?
Plus, Your Lordship may kindly see, my lords, he was not entitled to for the reason that I have filed my detailed counter, my lords. Your Lordships could see, my lords. He and his family members, they own more than 40 acres of land. Suppressing that, my lords, he has sought for it. Your Lordship may kindly see, my lords, para 6, page 2 of my counter, 6 and 7, where I have produced the documents and also, my lords, have detailed the extent of land owned by him. His mother herself, my lords, owns around 25 acres of land. He owns, my lords, around 7 acres of land. This he has suppressed. And his brothers, my lords, they own large extent of land.
Section 94.
Do you own these lands?
My lords, that is not by this petitioner, my lords. They are by the brothers and my lords, mother. And my lords, section 94A, my lords, specifies,
Kodi.
says,
Para
the
6,
proviso,
my
my lords,
Act Kodi. Sriram. 94A.
regularization of certain cases of unauthorized occupation by constituting committee, etc. My lords. The proviso to this section, my lordship may kindly see, my lords. Provided that the land so granted together with the land already held by such person shall not exceed 2 hectares of D class of land or its equivalent thereto.
Yes. So totally, my lords, in addition to what he holds, it should not
R2
exceed.
and R3 is for 7 acres.
Yes. Yes.
You're already a owner of survey number 140 standing in your name.
My lords, that the documents which are produced are all subsequent to the grant, not, my lords, before the grant, my lords. Lordship may kindly see, along with their statement of objections, the record of rights they have produced, my lords. Subsequent to the grant, not before.
When was the grant made?
Grant is in 2004, my lords. Grant is in 2004.
17/1/2004, my lords.
17/1/2000.
2004.
And you got it under a partition in 2005.
Please, my lords.
So your family already had a property,
Pardon
whether
me?
it was in your name or not. Your family had the property.
Yes.
It was undivided property.
No, my lords, but to, my lords, so far as this person is concerned, my lords, there is no other property standing in his name, my lords.
But your family owned the property in the name of your mother. You had a partition on 21/9/2005. As per this RTC. Vibhajane.
Vibhajane, this is the land which has been granted, my lords. 4.135, my lords, survey number 135 bar A. This is the land which is, my lords, the subject matter of this writ petition.
Granted is this survey number 135.
135.
ಯಾವುದು ನೀವು
A.
ಹೇಳ್ತಾ ಇರೋದು ಅವ್ರು ಇದ್ದಿದ್ದು ಯಾವುದು?
Annexure R1, my lords, the RTC they have produced.
Survey number 140.
Yes.
R2. 145 acres,
140 is
68.
subsequent to the grant, my lords.
Says.
ಇದು ವಿಭಾಗ 25/8/2006. ವಿಭಜನೆ ಇದ್ಲಿ ವಿಭಾಗ. Your family owns it.
This respondent, my lords, is neither an applicant who, my lord, sought for regularization,
Not
who is
necessarily.
no way
If-
concerned, my
If
lord.
somebody is going to misuse and abuse the process of law to get free land, he's filed a complaint, it has been considered. Your client wants to take land even though having 25 acres, claiming that he is in unauthorized possession and he needs to be given free land, thereby cheating somebody else. And everybody has to keep quiet. Nobody should challenge it. Not fair. A lot of landless people who are to be granted, the whole purpose is different. Petitioner is before this court.
My lords, the proviso says, my lords, they are entitled to, my lords.
If you have 7 acres, you are already more than one hectare and the rest, 2 acres.
2.5.
You have 3.5 hectares already. ಅದರಲ್ಲಿ 1-2 hectare, 1.5 hectare ತೆಗೆದುಬಿಟ್ಟು ಬೇರೆಯವ್ರು ಕೊಡಬೇಕಾಗತ್ತೆ. You are holding excess land because you are claiming for free land. Not to be done. Petitioner is before this court seeking for the following reliefs. The petitioner had applied for regularization of his unauthorized occupation in respect of land covered under survey number
135 upon A bar 2, my lords.
135
A bar 2.
A bar 2. 135A,
Yes, my lords.
measuring 6 acres, 6.93 acres, situated at Damnur village, Taluka and district Bellary. On a spot inspection being conducted, the petitioner was assigned 4.90 acres of the said land, and the assigned land came to be numbered as survey number 135 A bar 2. The first respondent, contending that the petitioner was not eligible for such grant since the petitioner and the family of the petitioners owned several lands exceeding more than 25 acres.
Then almost 40 acres. His brothers also.
The petitioner, his mother and brothers owned nearly 40 acres. And there was no need to regularize the same, had approached the Assistant Commissioner, who dismissed the appeal filed by respondent number 1, which came to be challenged before the Deputy Commissioner, who allowed the said appeal and remanded the matter for inquiry by setting aside the grant made in favor of the petitioner. It is challenging this order of the Deputy Commissioner that the petitioner is before this court. Ms. Pallavi Pachapure, learned counsel, appearing for the petitioner, would submit firstly that respondent number 1 has no locus to have filed an appeal challenging the grant in favor of the petitioner, and secondly, by relying on the proviso to subsection 94 capital A, she submits that even if the petitioner were to own certain lands, there is no embargo on grant of lands by way of regularization, since the petitioner would be entitled to 2 hectares as per the said proviso. Ms. Vidya, learned counsel, appearing for respondent number 1, would contend that there is a gross abuse of the process of law resorted to by the petitioner. The petitioner and the petitioner's family owning nearly 40 acres of land, government unassessed land, is sought to be taken possession of, is sought to be usurped by the petitioner to the detriment of the interest of other eligible persons. The petitioner cannot therefore be permitted to make use of the, abuse the law and seek for regularization of land merely because the petitioner is in unauthorized occupation of the said land. On that ground, she submits that the order passed by the Deputy Commissioner to hold a detailed and proper inquiry, being the one necessitated in the circumstances, need not be intervened with, and the above petition be dismissed. Heard so-and-so peruse papers. The contention of learned counsel for the petitioner is that the petitioner was in unauthorized occupation of survey number 135 capital A, as regards which the regularization application was filed, and 4.90 acres thereof had been assigned to the petitioner. It is not that the petitioner owned the land, but it is on account of the unauthorized occupation. A regularization has been sought for by filing form number 53 under Rule 108 CC of the Karnataka Land Revenue Rules. Thus, it is the requirement of the said rules that is required to be complied with by the petitioner to be entitled for regularization of the land, even if in unauthorized occupation, which is admitted to be in unauthorized occupation. Rule 108 CC is reproduced here under for easy reference. The aforesaid rule prescribes the manner and procedure in which an application filed under Section 94 capital A of the Land Revenue Act is to be dealt with. Section 94 capital A is reproduced here under for easy reference. A perusal of Section 94 capital A firstly would indicate for a committee to be constituted to consider any application for regularization of unauthorized occupation. Subsection 4 of Section 94 capital A indicates that the applicant should satisfy the prescribed conditions, including the extent of land held and unauthorizedly occupied by him, and have made an application within 1 year from the date of commencement of the Karnataka Land Revenue Amendment Act 2018. And the proviso thereof makes it clear that the land so granted, together with the land already held by such person, shall not exceed 2 hectares of D class land or its equivalent thereto. In the present matter, the classification of the land is not in question. Suffice it to say that as per the proviso to subsection 4 of Section 94, the maximum land that could be held by any person is 2 hectares, which translate to blank acres. The calculation. In the present case, the contention of respondent number 1 by producing various RTCs favor of the petitioner on 17/1/2004, and the same cannot be taken into consideration. A perusal of the RTCs which have been produced by respondent number 1 at annexure R2 and R3 would indicate that though the land has fallen to, though the said land were mutated in the name of the petitioner subsequently, the same were mutated in furtherance of a partition, thereby indicating that the lands were always belonging to the family, as regards which the petitioner is also a family, is a member and had an undivided interest therein. In that regard, I am of the considered opinion that it's not only the land that is mutated in the name of an applicant which would have to be looked into, but also the undivided interest, if at all, of the applicant in the family holding, which should have to be taken into consideration for determination of the rights under the proviso to subsection 4 of section 94 capital A. It is for this reason that the Deputy Commissioner has remanded the matter to the Assistant Commissioner for holding a proper inquiry to ascertain the lands which fall to the share of the petitioner. Though, of course, on the face of it, on account of the partition, the petitioner has derived title of 5.68 acres in survey number 140 and 1.52 acres in survey number 136A2, which would indicate that the petitioner had an undivided interest in respect of the said lands, which is more than 2 hectares. A remand has been made to provide an opportunity to the petitioner to place all the relevant documents before the Assistant Commissioner for consideration and for a proper order to be passed. Therefore, I do not find any infirmity in the said order. It is up to the petitioner to place all the documents that the petitioner wishes to rely upon before the Assistant Commissioner to enable the Assistant Commissioner to pass necessary orders. It would also be open for respondent number 1 to place all the documents that respondent number 1 relies upon to enable the truth to come out and for the Assistant Commissioner to pass necessary orders so that any abuse to the benevolent statute is prevented and the rightful person is granted land which is a scarce commodity. In the above circumstances, there have been no grounds made out. The above petition stands dismissed.
My lords, annexure R3, my lords, does not indicate partition. Kraya anta, it is purchase, my lords. That one survey number, your lordship may kindly.
Partition, will correct it. I'll note R3 is sale.
Please.
Request for the next matter 65.
Yes.
But though it is 2011 matter, my lord, some civil litigations were between the parties. Brothers were there. We'll get the instruction, my lord, week's time maybe.
Next week, any date may be fixed.
Both the councils seek for and are granted 10 days time to obtain instructions as regard the pending civil litigations.
Civil litigations.
So for their litigation, my lord, it has been dismissed up to RSA. I had filed a suit.
Pending litigation.
Next week, a date may be fixed.
Before that, pending. Released on 23rd January.
Please.
Serial number 67. Petitioner, request my lordship to kindly have it day after tomorrow.
The request of counsel for the petitioner released on 9th.
What would it? ಯಾರು ಹೇಳಿ ವಿಜಯ್ ಕಂಪ್ಯೂಟರ್ ಇವರು ಮೊನ್ನೆ ಅವರು ವಿಜಯ್ ಬೆಳಗ್ಗೆ ವಿಜಯಕುಮಾರ್
ಬಳಗೇರಿ ಮಠ.
ಬಳಗೇರಿ ಮಠ. ಸಿರ್ಲಂ ಎಷ್ಟೇ ಇತ್ತಲ್ಲ ಸರ್ ಅದು?
ಪಂಚಾಯತ್
ಸರ್ ಟೋಟಲ್ ಡಿಸ್ಟಿಕ್
48 ಅಲ್ಲ?
ಹ್ಞೂ ಸರ್.
ವಿಜಯಕುಮಾರ್
ಬಳಗೇರಿ ಮಠ.
ಕೊಪ್ಪಳದ್ದಲ್ಲ ಪೂರ್ತಿ ಅಲ್ಲ?
ಪೂರ್ತಿ
ಇನ್ನೊಂದು ಕೊಪ್ಪಳದ್ದಿದೆ, ಗಂಗಾವತಿ ನಿಮ್ಗೆ ಬರ್ತದೆ.
ಎಸ್ ಸರ್. ಅದು ಆರ್ಡರ್ ಕಾಪಿನ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ಲಾಸ್ಟ್ ಟೈಮ್. ಕೊಪ್ಪಳ CMC ಬರಲ್ಲ ಸರ್ ಅದ್ರಾಗ. GP TP ZP.
ನಮಗೆ ಗೊತ್ತಿರಲ್ಲ ಅಂತ ಅವರ ಹೇಳ್ಬಿಡ್ತಾರೆ.
ಅಷ್ಪಾಕ್ ಹೇಳ್ಬಿಡೋದು ಸೆಲ್ ನಂಬರ್ 48 ಭೂಷಣ್ ಕುಲಕರ್ಣಿ ಅಂತ ಹೇಳಿದ್ವಿ.
ನನಗೆ ಬೇರೆ ಸಾಹೇಬ್ರು ನೀವು ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಅಂತೇಳಿ. ಈಗ ಒಂದ್ಸಲ ಅವ್ರಿಗೆ ಗೊತ್ತಾದ್ರೆ ಅವ್ರ
48
ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳ್ತಾರೆ ಸರ್?
ಅದಕ್ಕೂ ಇದು ಕೊಡ್ತೀನಿ. ಎಷ್ಟೆಂತ ಪಾಸ್ವರ್ಡ್ ಆಯ್ತು? ಹಸುರಾಗಿ ಸರ್ ನೋಡ್ತೀನಿ. ಹಸುರಾಗಿದೆ ನೋಡಿ ಹಾಕ್ಕೊತೀನಿ.
ಫೈಲ್ ಅಲ್ಲಿ ಇರ್ತದೆ.
ಹೌದು ಹೌದು. ಪಟ್ಟಣ ಪಂಚಾಯತ್ ಅಂದ್ರೆ TMC ಬರಲ್ಲ, ನಾವು ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್. TMC ಪಟ್ಟಣ ಪಂಚಾಯತ್ TMC. ಸರ್ ಎಸ್ ಪ್ಲೀಸ್. ಮಾಡಿ. ALAGERIMA.
Thank you, sir.
ಸೈನ್ ಇಲ್ಲ ಕೆಳಗೆ ನಾನು ಎರಡು ಆರಾಗ ಎರಡು ಸೈನ್ ಇಲ್ಲ ಇಲ್ಲ ನನ್ನ ಜೂನಿಯರ್ ಕೇಳಿದ್ಯಾ ಅಪ್ಪ ಅಣ್ಣ ನೀನೆ ನಾನು ಕೇಳಿರ್ತೀನಿ ಹಾಂ ನಮಸ್ತೆ ಹೇಳಿ
ಇಲ್ಲೇ ಬರ್ತೀಯ ಇಲ್ಲೇ ಮಾಡ್ತೀಯ ಅಲ್ಲಿ ಬರ್ಲೆ